which creates the situation of making a determination of proceeding without that juror and excusing the juror, or doing other matters today and then proceeding with the trial on Monday. And both the prosecution and the defense for that particular jury have requested that that juror not be excused and that we do things without the jury being in the courtroom so that the juror could return on Monday. That juror is on the gold jury, and there is some testimony that would occur today before the blue jury. Counsel for both the prosecution and the defense expressed to the court the concern that there's already been one juror excused, and they're concerned that if deliberations proceed and there is any additional problems, that there might be a absence of a sufficient number of jurors, even though we have 5 alternates on that particular jury. So the court will first wait and see if we have all the other jurors here before making a final decision on the matter. But there are other things that we should be discussing here today. One of them has to do with the schedule. And regardless of whether we delay further proceedings with the gold jury until Monday, I do intend to discuss with all those jurors who are present here today the schedule of the trial, and the juror who is absent, if that juror remains on the jury, can be updated by the court reporter reading back my remarks to that juror upon her return if she remains on the case. But I think it's only fair at this point to give the jurors additional information as far as the schedule of this case. Counsel have discussed the matter among themselves this morning as far as witnesses who are going to be called by the defense. Before we get to that point, however, the people still are presenting the people's rebuttal evidence, and assuming that we proceed today only with the blue jury, with the limited amount of testimony that has been or will be set aside for that jury only, and the rest continuing on Monday, how long will it take for the prosecution to complete its rebuttal?
Your Honor, I don't know how long the cross of Brian Anderson is going to take on Monday. We have Brian Anderson, Marcy Eisenberg, Karen Farrell, who I don't think will take very long, and Detective Zoller to do basically clean up and some slight impeachment of witnesses from the police report that the defense already has.
Yeah, speak up.
I'm sorry. Detective Zoller, I anticipate will take an hour, and a lot of it's going to be just the kind of normal things an investigating officer does, impeachment of witnesses and from the police reports. You know, they told us this, they testified differently, things like that. I haven't finalized his testimony. And I can fax a list of the topics to the defense this weekend. And then, so it's Marcy Eisenberg, who I anticipate will be an hour on direct, Karen Farrell, who should be under an hour on direct. And then I don't think I have more than 1 or 2 questions of Brian Anderson on redirect so far.
I have about another hour of cross of Brian Anderson.
All right, so it's...
Well, hold on. Is there any cross by the co-defendant for Mr. Anderson?
Half an hour total.
So I think we're looking at Tuesday before we rest, realistically. Tuesday noon.
How long is a cross-examination, Ms. Eisenberg?
Well, I think it differs probably for Eric Menendez, no more than an hour, maybe longer for Lyle Menendez.
I can't hear you.
I said it may be longer for Lyle Menendez.
Well, what's the estimate for the co-defendant?
Hour and a half maximum.
All right. And for Detective Zoller? What is a cross-examination estimate?
I don't know because I don't know what the topics are yet.
Well, let's assume you want to bring out things from his testimony. What is it that you estimate will take?
Well, Your Honor, if they call him last, and if we're permitted, we were going to put him on for an hour or so to bring out impeachment stuff. So I guess the combination, if the people don't object, since we'd be right on the bridge,
we don't object.
probably jointly we'd do an hour and a half on him for what I have to bring out and then for what Ms. Lansing has to bring out.
I think that's correct.
And then you can take this hour out of our list.
And the defense has submitted a list of 16 potential witnesses who are going to testify or may testify. Is this a list that you feel is accurate as far as those witnesses who you intend to call?
It has more witnesses rather than less witnesses that we intend to call. We put on here everyone that we can think of that we might call. For example, I might not call Dr. Maloney. And
What
and
would
the
he
defendants may
testify?
not testify.
What would Dr. Maloney testify to in rebuttal?
Well, I was permitted to hold him for rebuttal.
That was Dr. Vickery.
No, it was both.
I don't recall Dr. Maloney being held for rebuttal.
Yes, it was both.
Well, I'd have to hear an offer of proof as to Dr. Vickery and Dr. Maloney as to what they would say that would not be repetitious of other witnesses.
Well, Dr. Maloney just tested Eric Menendez. He did psychological testing
Right.
on him. And if he were
You
called, that's all he
You
testified.
find in the record where Dr. Maloney was reserved as well. I don't recall that. I recall the reference to Dr. Vickery. And same with Dr. Vickery as to what it is that he would say that hasn't been said by someone else already.
Well, whether someone else said it or not, he's the treating physician.
Well, again,
He's a psychiatrist, which no one else is. He's the treating physician. He
all
saw
of
the
that might be
defendant.
true, but then you elected to call someone else in his stead. So the issue is, how many of these witnesses are you going to be calling?
Well,
And
you've
at some
got
point, the
list.
trial starts to wind down, and just because you decide to call someone else first doesn't mean you can call someone else later.
Well, we'll deal with this later, Your Honor. I
Yeah,
don't wanna-
but I'm telling you now that I'm going to want a specific offer of proof as to these witnesses, not just the fact that you want to call them, but as to what they will say. They won't be repetitious. What does Alex Curry have to say in rebuttal?
I think she is being called to, can't find the word right now, corroborate the testimony of Judelon Smith
And
concerning,
did Judelon Smith testify during the people's rebuttal?
no,
So why is she a witness that should be called in rebuttal?
that's true. Good point, Judge.
Judelon Smith was cross-examined by the people on cross-examination. So
That's always the case on when a witness is called, but then
Sure.
why is it that you're entitled to call somebody in rebuttal to rebut the people's rebuttal? She was cross-examined during the defense case. So think through any of these
We'll think it
witnesses
through.
along
We'll
those
see what Zoller's
lines.
going to say vis-a-vis Judelon Smith. I mean, it's Zoller is.
Well, I don't care. All of these witnesses, I want you to think through as to what it is that relates to rebuttal, proper rebuttal, not just the fact you might want to call somebody. Who is this KABC radio reporter?
It's a radio representative, Your Honor. It's our understanding that Mr. Grant Walker, who denied on the witness stand any interest in publicity as a motivating factor for his becoming a witness in this case, did a radio talk show interview before he ever went to, before he sent his wife to the police. And we are in the process of obtaining his tape recorded remarks to KABC Talk Radio. So what we would propose to do is to call a representative from KABC Talk Radio. I'm not sure what the scope of that testimony would be. The people are also interested in hearing that tape. Whether we play his remarks. I don't know if they're impeaching or not since we don't have the tape, but the idea would be if they're impeaching, we would play the impeaching parts. If it's not impeaching, but it's just the fact that he voluntarily called in and we want to present that fact that he denied any such interest in becoming a witness.
Evidently, he did use a false name. So if he was getting publicity, it was for someone other than himself.
Well,
When you say
that
evidently,
use
has
of
this
false
been-
name is
has this-
interesting.
Has this been pinned down, or is this just still
Well,
rumor, or what?
he admits that he did this. We're simply,
Okay.
but we just found out about it.
Okay.
And he
All right.
admits he did it, and we're trying to find it.
Okay. And a legal expert, 30 minutes for what purpose?
It's your issue.
I'm The legal expert is rebuttal for Ms. Pizarczyk.
If it's the issue of appellate things, I think the court can take judicial notice of the way it feels of appellate.
That's not something that could be properly a subject of judicial notice since it's a factual issue, but certainly you can work out a stipulation that I can't see 30 minutes, first of all, for someone to testify for cases appear in reported opinions. And
With all the estimates, Your Honor, we've been very generous in them, so we don't mislead the court. I would expect the actual testimony would be closer to 10 to 15 minutes, but
well, again,
out of an abundance of caution. It's just to address that particular issue, what the appellate process is and what cases are and are not included in.
well, the appellate process is meaningless. It would just be what is and what is not in
Right.
reported opinions, and that's something you can stipulate to. I don't think it requires any testimony.
It would be our request to put on a witness.
Well, I
expect it
would
to be very-
again suggest that you try to work out stipulations and try to expedite the completion of the trial rather than prolong it. What about Delicio? Who and what is that?
Mr. I just don't remember his first name. Mr. Delicio, Your Honor, is the limousine driver on August 31st who is being called to further impeach Mr. Valentine.
Okay, and as far as character witnesses for Mr. Anderson and Ms. Pizarczyk, you have 30 minutes for Mr. Anderson and hour and a half for Ms. Pizarczyk. Character witnesses can take an hour and a half.
Well, there's other aspects besides character, but we would be happy to discuss with the court in camera who these witnesses are. The one for Brian Anderson, the 30 minutes is trying to be generous with, because of the usual arguments that happen when about the scope of, I'm sort of including in there the usual 402 arguments about the scope of the character witness. And the same is true with the Jamie Pizarczyk witness, but that witness goes beyond just character, and we'll be happy to explain that to the court in camera.
That witness is probably more accurately characterized as an impeachment witness.
Right.
All right, but again, there's no way we can conduct any 402 hearings without counsel revealing to the prosecution what it is that you expect to elicit from the witness. So
Well, we don't.
prior. All right, let's have the blue jurors who are outside come in so that they don't have to wait outside. Right, as soon as these jurors come in and we get more information about how many jurors we have here, we'll proceed. Have we done a count yet?
That would be all of the jury.
Okay. And then if you can check with the gold,
We're short one.
in addition to the one that's all right. Okay. And if there are these witnesses who are called by the defense, would the prosecution expect to call any further rebuttal witnesses?
Is there such a thing, Your Honor? I think that's the last word.
It depends on what comes in. Obviously, there will be an end to it, but we'll have to see what is elicited by the defense. You're calling two witnesses that you say that you had reserved from direct. And
Those that I think they have a right to reserve.
so at some point, if that is true, then they would have a chance to call witnesses to refute them at the very least.
Your Honor, I can't say at this point. Definitely, our inclination is not to call further witnesses, but I can't promise the court since I don't know what these people are going to say.
All right, and as far as Maloney and Vickery, as I said, I'll require a detailed offer of proof by the defense prior to their testimony if they are offered, so that we will have an idea of, number one, whether they would be permitted to testify, number two, whether these time estimates are accurate based upon other similar type witnesses. Those estimates are much lower time-wise than we've ever seen before with this type of witness.
Because I'm not putting them on to duplicate what other witnesses
Okay, well then
are limited for.
you can inform me of that and also research the issue of whether Dr. Maloney's testimony was actually reserved. Assuming there was a penalty phase, how long is it that the defense would expect that to take?
How long,
The people have indicated they, at least at the beginning of the trial, that they did not intend to offer any additional evidence. I assume that that's still the situation.
Your Honor.
Okay, how long would the defense evidence be?
1 week. 10 days.
This is not duplicative of between the two, or?
It may be the same witnesses. Two separate trials running.
Are there going to be two juries in the courtroom at the same time?
I don't think so, not for penalty phase.
Well, we'll have
I
to
mean,
play that by ear. If the witnesses are
that's-
testifying about the same matters, there certainly wouldn't be any need to have different time set aside for each jury. I have no way of knowing precisely until we know what the evidence would be.
Your Honor, the other thing is that the court should factor in that it might depend to some degree on the length of deliberations, but if the deliberations are relatively brief, we might need a few days to get our witnesses organized before we can start penalty phase.
Well, I understand that. I'm just trying to deal with the time estimates once it gets going. I assume you do have witnesses here in Los Angeles that wouldn't require transportation to.
Really,
Be here.
two people.
All right, as deliberations proceed, it might be that I will confer with counsel in relationship to having some witnesses here so that we won't have a large hiatus between verdicts and next phase, if there was to be a next phase. But we can discuss that later. All right, I'm going to, as soon as all the jurors arrive, discuss matters with them. As I indicated, I will give them some update as to the schedule, and then afterwards, we'll take testimony with the blue jury. My inclination at this point is to not proceed with the gold jury, since we are at a stage of the case where if these time estimates hold true from what you've told me, we might need some additional alternate jurors substituting for those jurors who are seated. So at this point, I'm not inclined to excuse a juror, but as the trial proceeds further, that circumstance could easily change. We can't just lose court time, but we do have other matters that we have to deal with without the jury, including discussion of the exhibits that has yet to be accomplished. We have about 400 exhibits that have to be discussed and ruled upon prior to completion of the case. And also matters dealing with the testimony of certain witnesses who are upcoming. I guess Ms. Eisenberg is the one that has yet to be discussed.
Your Honor, is there any way we could perhaps have some finality today as who's going to argue first, since there's 4 days of preparation time coming up tomorrow? So no one's been willing to say they want to go first versus the Lyle or the Eric Menendez jury.
You know, to some extent, as I said, I was willing to let the parties negotiate that, because it really didn't matter to me which side, which defendant went first. Is that something that both defendants want to?
I agree that they can go first.
And what about the prosecution?
That's fine.
All right, then the Lyle Menendez defense wants to proceed first. The only caveat I would have would be if, for whatever reason, there are some scheduling problems with jurors that perhaps they have some personal or medical appointments or something that would better fit in with the other defendant going first. I have no way of knowing that, but it's possible that, and I don't see any major obstacle to either defendant's case going first. So since there was no real decision until this last moment.
Well, actually, several weeks ago when we talked about this before, there was some indication that the Menendez team would go first. That had to do more with my, at that point, unexpected personal situation. All the unexpecteds have now occurred, I'm happy to say. Nevertheless, I've sort of always had it in my mind that they'd go first, because I'm still preparing relatively complicated witnesses here towards the end, and so would welcome having a couple of more days to prepare final arguments.
Well, that might work out, might not. As I said, there are other people involved and their schedules as well. And because the trial has gone on longer than the time estimates provided by counsel, their situation has to be certainly considered as well in deciding some of these matters.
Would the court be inclined to make inquiry today, or would that be too much of a loaded weapon to ask them if they have holiday plans?
Well, what I'm doing today is giving them updated information of things that I have learned from you, and give them some idea of some of the procedures that we'll be using. As I said, we have one juror who won't be here today, but that juror can pick up my remarks from the court reporter reading them back. Would that be agreeable with the defendant, Lyle Menendez? Is that agreeable, Mr. Menendez?
Yes, it is.
Okay. Then we'll do that so that these jurors have an idea of what to expect, and they can provide me with information as far as their situation. I've, throughout the trial, received such information, and I expect more to be generated by this update regarding the schedule. All right, are we still missing one juror? Is that right?
No, sir, all the jury except for one.
Okay, and then let's have all the jurors in, and I'll explain to them the schedule, and then we'll proceed with the blue jury with some testimony, and then the lawyers and I and the defendants will discuss exhibits or testimony of other witnesses yet to testify.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
As far as today's schedule is concerned, let me give you information about that first. One of the gold jurors is not here today. She had a situation where one of her children was taken ill, and she had to take that child to the doctor. And as you're all aware, we do have alternate jurors, and alternate jurors are here for the purpose of substituting to fill in when necessary for those jurors who are excused. The particular juror who's not here today is an alternate juror, but obviously we do need the alternate jurors available for the purpose of substitution whenever necessary. We do have quite a bit of trial left before the case is completed, and I'm going to be discussing that with you this morning as far as the schedule of the trial and what you can expect. But as far as today is concerned, I'm not inclined to excuse that alternate juror and continue with the trial without that juror present because of the expected length of the trial. It might be that we'll still need the alternate juror to fill in if somebody is excused. And so I'm not at this point, at least today, not going to proceed without that juror. There is some testimony that we can take with a blue jury so that it'll, for at least for a short period of time, the blue jury will be in the courtroom when testimony is taken this morning, and then will be excused before noon, I would expect. And the gold jury would also be excused this morning, and then we'll have you all back on Monday after the Thanksgiving break. But before I excuse the gold jury, I want to give everybody a little more information about the trial schedule here so that everybody is sitting here, not just the lawyers in the court, but everybody, including the jurors, sitting here with the same information. So you're certainly entitled to it. I'm going to have the clerk hand out to you all a calendar for the month of December so that at least you have that in front of you. And then I'll give you some more information. I have today been talking to the lawyers about how much longer they expect the trial to be. Their time estimates in the past, both sides, have been inaccurate. They've underestimated how long things would take, and I think you've seen that during the course of the trial. Hopefully these estimates are a little more accurate. There's no way anyone can be 100% sure things take longer than sometimes one would expect. We have also had, obviously, situations where people have been ill or for other reasons been unable to be in court. So those things have occurred in the past, and I suppose we can anticipate to some extent they might occur again during the balance of the trial. Things might happen. But let me now go through with you what is expected here from what the lawyers have told me. Although it doesn't show on the calendar, and this is just a blank calendar, there's nothing on it, but the month of December, we'll be back Monday, which is the 29th of November, and the 30th of November, Tuesday. And by the sometime Tuesday, it's expected that the people's case will be completed. Their rebuttal case will be completed. And then the defense will present its rebuttal evidence or additional evidence that it has. I've received a request by one of the jurors in relationship to this coming Monday, the 29th, that juror on the blue jury wants to, has a medical appointment and has to get out at around 2 o'clock to attend that appointment, assuming and that she's tried to make arrangements to do otherwise and hasn't been successful. That means that if we do proceed with her appointment, that we would most likely work through the lunch hour to accommodate that. So you might want to think of that when you come in on Monday, so that we would have most of the day before she leaves. But the people's case will be completed by Tuesday of next week with the time estimates I've been provided with. Then the defense would proceed, and from what's been presented to me, it would appear that probably the defense case would be completed by the 6th or 7th of December. Possibly by Friday the 3rd, but possibly into the 6th or the 7th of December. Then after all the evidence is in, after both sides have put on all of their evidence, then the case is argued to the juries. And there are separate arguments for each jury. So you can expect that based on the current schedule that perhaps on the 8th or so of December, there might be a day there where the lawyers and I will have to complete our final discussions regarding the instructions I'll be giving you. And I really can't do that with them until all of the evidence has been presented. So it might be that there will be a gap of a half a day or a day between the completion of the testimony and the beginning of argument. But then the argument would start and we'd do it one jury at a time. When that jury is receiving its or listening to the arguments, the other jury would not be in the courtroom and would not have to be in the courthouse. And the argument could take a couple days, probably, maybe a little longer to complete. It's hard to know. So for one jury, you could have argument for maybe 2.5 days, something along those lines. And then the court's instructions to the jury, and the instructions take a couple hours, probably an hour and a half of instructions I read to the jury. The current thinking is, and this is not final, the current thinking is that argument would proceed with the gold jury first, which means that the gold jury would be in the courtroom perhaps towards the end of the week of December the 6th, and the blue jury would not. Blue jury could go about your business, whatever you would normally do when you're not in a courtroom, while that argument was going on. And then we would have the gold jury instructed by me and start its deliberations. So, you know, if you want to make note that perhaps the gold jury would start deliberations around the beginning of the week of December 13th, somewhere in that area. And you might want to mark on the calendar that December the 24th and December 31st are legal holidays here. So those are 2 days that the Christmas is observed on the 24th and New Year's on the 31st. So once the gold jury starts deliberating, after the argument and the instructions are completed towards the early part of the week of December 13th, then the blue jury would come in and we'd have you in court, and you would hear the arguments of the lawyers and my instructions, and would look like towards the end of the week of December 13th that you would start your deliberations. There have been some inquiry of jurors. I think it was asked of me earlier about how deliberations occur, and it might have even been asked during jury selection in relationship to what's going on if one jury reaches a verdict and another jury is still deliberating. Let me discuss that with you a little bit. And this relates to what I'll be asking you here in a few minutes. I haven't done this in a little while because we've been pushing to get the evidence on before you when we've had you in the courtroom, but I'll be asking you again before I let you go today whether you've heard anything about the case outside of the courtroom or been exposed to anything outside of the courtroom. But that also relates to the situation in regards to verdicts and receipt of verdicts and things of that sort. Assuming one jury starts deliberating and reaches a verdict and the other jury is still deliberating, the question is, well, what should we do in that situation if one jury comes in and says, well, we have a verdict and the other jury is still deliberating? The concern is that if the jury that's still deliberating somehow gets wind of what the other jury has decided, that could have some impact on the jury that's still deliberating, because even though you do everything in the world to avoid any exposure to anything about the case, it's possible that perhaps you might somehow inadvertently be exposed to what the other jury has done in its making its decision. So what I would propose to do is, even though one jury might reach a decision before the other jury reaches a decision, to hold the decision without announcing it until both juries have arrived at decisions in the case, so that we can do them at the same time, if that's possible, depending on circumstances. But so that's a possibility of what might happen. Even though one jury might reach a decision, we still would hold it off until the other jury reaches a decision as well. And that after verdicts are reached, if they are reached in this case with one or both defendants, and as I've told you before, and as I'll remind you later, you must make your decision only as to the defendant to which you have been assigned, in your case, as to that defendant. If the jury reaches a decision that causes the case to go into the penalty phase that I've discussed, and as I've discussed with you during jury selection, the penalty phase is a phase of the trial that only occurs if a jury finds a defendant guilty of first-degree murder and finds one or more of the special circumstances true. Then you go into a penalty phase, and as far as the penalty phase, time estimate-wise, it could take 1 to 2 weeks, perhaps 2 weeks for that to occur. That would occur after only if a defendant has been found guilty of first-degree murder with special circumstance, and then penalty phase would occur afterwards. So getting back to the calendar of December, there's no way of knowing how long your deliberations will take. I've asked the lawyers how long their time estimates would be for the trial, and we've had those. I can't ask you how long your deliberations will take because none of you will know until you start in on your deliberations, and you won't know until the deliberations have been completed. So assuming the deliberations start for one jury towards the beginning of the week of December 13th, the other jury towards the end of the week of December 13th, then the jury would be deliberating for however long it takes for the juries to reach decisions. And then after that, if there's a penalty phase, it would proceed, as I've indicated, it could take approximately 2 weeks to complete that, and then there would be more deliberations after that. And so from how I look at the calendar, it would first depend on when verdicts are reached as far as when we would do anything else, if there was anything else to be done as far as any other proceedings in the case. But it could possibly be that because of verdicts that are reached or the length of deliberations that we would be in trial in January in this case. So just from looking at the calendar, that seems to be a good possibility, or at least a possibility. I can't give you any more information than that. So the reason I'm going through this with you is so that you have some idea of what the schedule will be, and you can let me know if you have any problems based upon the balance or the expected balance of the trial. You were given a certain time estimate as to when you were told the trial would be completed, and this schedule that I've given you, it goes beyond that. So hopefully none of you will have any problems that will prevent you from completing your role as jurors on this case, but certainly if you have some hardship situation that you want to let me know about, you should feel free to do that. But as I said, we hope that we could keep you all on as jurors on the case. We know you've been very dedicated and sincere in your efforts to be here, and we appreciate that, and we would hope very much to keep you all as jurors until the trial is completed. But I certainly do want to give you as much information as I have as far as what could transpire during the course of the trial. So that's basically the time estimate here. And what I would suggest is that if anybody has any particular problems, you can write me a note. You can bring it back on Monday and let me know about it if there is such a circumstance that you want to let me know about. Before I let the gold jury go, do any of you have any questions about the schedule so far? Yes.
If we have to wait between verdicts, like one jury and the other, will the one jury be in the courthouse while we wait, or will we?
That's a good question, and I'll talk to you about that. It's possible that we'll want you here. I don't know, and I'll talk to lawyers about it as well. But it could be that we'll want you here just so that there is that additional exposure that you might have if you go to work or whatever. People start pestering you, say, well, what did you decide? What happened? Even though nobody knows about it, it hasn't been announced, it might be better. You might feel more comfortable being here than going to work. So that's a situation as well, because once you reach a decision, until it's announced in court, you can't tell anybody about it. You can't discuss it with anybody. So it's a situation, again, that we'll discuss. But in my experience in the past, a lot of times jurors feel more comfortable being able to come into the courthouse rather than going to work and be exposed to that sort of situation. All right. Anybody else have any questions? Yes, sir.
I've sent 2 books.
Yeah.
The conflict. I haven't had any feedback.
Yeah. Okay. You have a couple of dates. You've changed your dates, and then now it's the right 20th and 21st. Okay. What I'd like to do is get some more. If you can just put down in writing more specific detail as to what it is, and depending on your situation. Another thing that was asked in a note a while back: what happens with the alternate jurors during deliberations? I think I mentioned this during jury selection, but it's something that bears repeating. Although during deliberations, only the 12 jurors who are actually deliberating and who decide the case can be in the jury room, we need the other alternate jurors in the courthouse as well for this reason, because if there's a request by the deliberating jurors, whichever jury makes the request, and we would deal with each jury separately. One jury makes a request and we deal with that request with that jury only. The other jury is still going about their business, doing what they want to do. But when we have a request for, say, a clarification of the legal instructions or a request for testimony to be read back, when those things are dealt with, we have not just the 12 jurors, but we also have the alternate jurors come into the courtroom and participate by listening to the testimony as it's read back, or listening to my clarification of any legal instructions, because there's always the possibility during deliberations that one of the jurors would be excused and one of the alternates would have to step in. And that alternate juror would have to be in a situation where he or she has heard and seen everything that the other jurors have seen and heard. And the only way to do that is to have the alternate jurors here during deliberations. And although it's an imposition on the alternate jurors, we have to do that. So as far as your question, you at this point are still an alternate juror. We'd have more flexibility dealing with your situation as an alternate juror. And if there was a request for reread or clarification, it could very well be it wouldn't occur on those 2 days anyway, or we could work around it. But I will need a little more information from you, and then I'll certainly address it. As I indicated, we're not going to put anyone in a situation where they suffer undue hardship as jurors on the case. All right, anybody else? Yes, sir.
Should penalty deliberations be required? Would there be a waiting period between the verdict and the start times of the penalty deliberation?
You mean after one? Well, there might be a few days. A short period of time. It wouldn't be a long period of time, unless these things can all depend on more input I get from the jurors as far as what you folks feel is, we're getting into holiday season, and it might be that there might be some days that everyone would want to be off, and I'd certainly accommodate that as well. But at this point, I don't want to solicit that. I just want to give you an idea of what the schedule could be. But there's a possibility that there might be, if there was a penalty phase, and as I said before, the fact that we discuss that phase of the trial should not in any way suggest that we'd ever get there. It's just something we have to be aware of as far as your schedule is concerned, that there could be a slight delay between the end of the guilt phase of the trial and the beginning of the penalty phase. But it wouldn't be very long unless I heard from everybody that you wanted a certain number of days, or it would fit in everyone's schedule, which is possible. And I'd certainly listen to the jurors' requests in that regard. Anybody else? Yes. After it's announced in court, yes. No, because the rule is, and the rule will remain, that the jurors cannot discuss their deliberations and cannot discuss the results of their deliberations until it's announced in open court what the result has been. Because if you did, then you would be discussing things outside of the jury room before the verdict was reached, and that would be a violation of your oath as jurors. So the alternate jurors would be in the same position as everyone else outside of the 12 jurors. They won't know what the result is until it's announced in open court. All right. Anybody else? Any questions? Yes. Oh, yes. Oh, yes. Yes, sir.
What's the results have been announced? How soon will it be announced in the court?
Well, as I said, depending on if we had both juries with decisions, assuming we had both juries reaching decisions, we would do it as quickly as we could, within the time frame of giving everybody notice of that. But as I said, we'd want to wait, if we could, for both juries to reach decisions before we announce them.
It will be within the next day or that day.
If both juries have reached decisions, yeah. I would give you more information about that as we got there. It's hard to evaluate or plan for that until we know exactly what's going on. Anybody else? Okay, and as far as the one gold juror who's not here today, what I'm going to do is when she comes in on Monday, have the court reporter read back my remarks here so I don't have to repeat them for her. And so she'll be aware of what's being said, and so she can deal with any problems that she might have, similar to what I've suggested that you might do, giving me any notes or requests or things of that sort. Okay, then what we'll do before I let you go is go through the same process that I have in the past. I do this throughout the trial to find out whether you have been exposed to anything about this case in any form whatsoever outside of the courtroom. It's important that I find out about it during the trial. It's too late and would be a violation of your oath as jurors to let me know after the trial was completed that you had been exposed to something during the trial that you didn't let me know about during the trial. You have to let me know now so that we can deal with it while the trial is ongoing. So let me first ask the gold jurors whether any of you have been exposed to anything outside of the courtroom in any form whatsoever about this case other than what you have already disclosed to me. Anybody? Would you raise your hand? Okay, then what we'll do, nobody has, what we'll do is excuse you folks and wish you a happy Thanksgiving and ask that you return Monday at, so we can start up promptly at 9 o'clock. So we get here a little earlier than 9 o'clock and we'll proceed. And what I would do is if this situation remains with the blue juror and there is no testimony that relates only to the gold jury, what we'll do is most likely work through the lunch hour on the Monday so that we can maximize our time, and it would be perhaps leaving around 2 o'clock so that that juror's appointment can be met, but we would still hopefully get those 2 additional hours that from noon to 2 o'clock to fill out most of Monday, and then we would proceed regular schedule the balance of the week. So as far as gold jury is concerned, happy Thanksgiving. We'll see you back here on Monday. And as to the blue jury, same question of you. Have any of you been exposed to anything about this case in any form whatsoever outside of the courtroom other than what you've already told me about? Okay. All right, then, are we ready with the witness for this?
I believe so, but Your Honor, maybe if I briefly, I wanted to ask the court about something.
Sure.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
In the evening, yes.
And where was this?
At the Sheraton Hotel in New York.
Was the U.S. Open being played during that period of time?
Yes.
Do you recall how it is that you came to be with Eric Menendez that night?
He just joined us that evening. There weren't any rooms available, so we spent the night in our room.
Did you on that night see Lyle Menendez?
No.
Did you know at that time Lyle Menendez's girlfriend, Jamie Pisarcik?
No.
Okay, did you see her that night?
No.
Did you know how Eric Menendez found you at the Sheraton Hotel?
I'm sure he knew we were staying there.
Now, he didn't have a room that night, is that correct?
No.
So did he ask if he could spend the night in your room?
Yes, I invited him to.
Was it just a single room?
Right.
And what was the arrangements?
2 queen-size beds.
At some point, did you see a bodyguard that night, August 30th?
Yes.
And where did you see this person?
He was with Eric.
Do you remember what he looked like?
He's a large man. I guess heavy set.
What race was he?
Caucasian.
Did you have any interaction with this bodyguard?
We spoke with him.
Do you recall what happened that night with Eric Menendez in your room?
I don't know what you mean.
Okay, were there any phone calls that came in?
Eric was on the phone. Made several phone calls or received some. I don't know what the conversations were.
Do you recall a call from his brother Lyle Menendez?
Your Honor, I would object and ask to approach.
All right.
As always, questions that are objected to and not answered are to be disregarded by the jury, since questions and comments of counsel have no significance other than in relationship to the answers given by the witnesses to the questions. All right, your next question, please.
Thank you, Your Honor. Mrs. Heffernan, did Eric Menendez, during the period of time that he spent in your room, in that hotel room at the Sheraton, did he receive any phone calls?
Same objection, Your Honor.
Overruled. You can just answer that yes or no. Do you receive any phone calls? If you remember.
I believe he received some calls.
Okay, and did he actually make calls from your phone in the hotel room?
Yes, he did make some calls.
Were you present when he made the calls?
Yes.
Was he making calls to airlines?
When?
Sometime
The night before?
Well, the 30th of August is the first time he spent with you, is that correct?
That's the night he stayed over.
That night, did he make calls from your room to the airlines, some airline?
I don't believe he did that night.
The next morning?
The next morning, he placed telephone calls to the airlines.
Did you overhear his conversations?
I knew what he was doing because we were talking about it.
Okay, what did he tell you what he intended to do the next day? That is, on August 30th of 1989, what did he indicate to you?
Objection, Your Honor, since that's not noted.
Rephrase the question.
Okay. Did Eric Menendez on August 30th tell you what he intended to do the next day?
No.
Okay. At some point, did he tell you that he had to get a hold of an airline so that he can get a ticket back to Los Angeles?
Conversations regarding the airlines, I don't believe occurred until the next morning. I don't remember anything the night before.
The next morning, what did you hear Eric Menendez do on the phone?
No, I'm going
Or
to
say on
object
the
that
phone.
now for proof on the same basis as the last objection. So.
Rephrase the question.
Did you, the next morning, August 31st, hear Eric Menendez on the phone with an airline?
Objection, Your Honor, down to personal knowledge.
He was making phone calls regarding reservations. Who he was calling, I'm not sure. Travel agent, airlines.
Did you ever, during the period of time that he was with you at the Sheraton Hotel, did he ever indicate to you that he wanted to get back to Los Angeles on the next day, the 31st?
That's what he was making reservations for, because he wanted to return to Los Angeles.
That day, that is August 31st?
That day. Mm-hmm.
Do you recall approximately when you woke up the morning of the 31st of August?
I'm sure it was early, 6:30, 7 o'clock.
Now, you've indicated that there was a bodyguard who was with Eric the night before, August 30th, correct?
Correct.
Did you ever have any conversation with the bodyguard?
I told him I didn't want him staying in the room that night,
Okay.
and so he sat outside the room.
Did anyone provide him with a chair to sit outside the room?
I did.
You did? And the next morning when you woke up, was the bodyguard sitting on the chair outside of your room?
Yes, he was.
Okay. Do you recall going to breakfast with Eric Menendez and the bodyguard and your husband, Mark?
Yes,
And where did you go to breakfast?
in the hotel.
Do you recall approximately what time that was that you went to breakfast?
Well, it was after Eric made the phone calls, so probably an hour later, 8 or 9 o'clock.
At some point, did you offer your American Express card for Eric Menendez to use to get his plane ticket?
Yes,
When was that?
while he was on the telephone, unable to book a flight on his card.
So you actually heard the conversation.
Or he told me, one or the other.
Did Eric Menendez ask if he could use your credit card?
He either asked or I offered it because he wasn't able to book a flight.
Now, at that point that he asked, did you make arrangements for his flight, or did Eric Menendez make his own arrangements?
I know that at one stage I had to get on the phone because
I'm going to object that the answer is not responsive, and I think the actual answer is beyond your personal knowledge.
Objection sustained. Why don't you rephrase it?
Okay. Did you actually talk to somebody from an airline regarding a flight for Eric Menendez with respect to your American Express card?
yes,
Your Honor, at this point, I would again object on the basis that we approached on before.
Overruled.
And did you make those arrangements?
I attempted to, but I couldn't book the flight by telephone. It was necessary for him to go to the airport with the card.
Now, do you recall when you gave him your American Express card?
At breakfast, probably.
At some point that morning after breakfast, did you leave the company of Eric Menendez and his bodyguard?
Yes,
And what did you then do?
probably went shopping.
Now, was your husband Mark with you the whole time during this breakfast?
No,
Had he left quite a bit earlier from your departure from Eric Menendez and his bodyguard?
I object to the use of the word kids.
Sustained. Rephrase the question.
Okay. How long did your husband stay with you at breakfast?
he ate breakfast quickly and left, and then we remained for probably another 15 or 20 minutes.
And where did your husband Mark Heffernan go?
He was attending a seminar in the hotel.
After breakfast, did you ever go to the U.S. Open?
And I'm going to object to the form of the question. Vague, ever?
Rephrase the question.
After breakfast, did you go to the U.S. Open?
Not during the day.
At some point, did you say goodbye to Eric Menendez?
Yes.
Okay, and did you actually see him get into a limousine and leave for the airport?
No.
Okay, from the restaurant where you're having breakfast, did you go up back to your room?
Yes.
Okay. Did you see Eric Menendez anytime later during that trip?
No.
Did Eric Menendez indicate to you why he had to get back to Los Angeles?
No, he was just in a hurry to get back.
Were there arrangements made for the return of your credit card?
Yes.
And how were those arrangements made?
The security guard was going to drop it off at the front desk.
And did you go to the front desk later that day and retrieve your
That
American
evening.
Express card? Sometime later, did you get a bill from American Express showing a U.S. Air ticket?
Yes.
And do you recall whether or not that was for $648?
I believe it was.
Thank you. I have nothing further at this time, Anna.
Cross-examination.
Mrs. Heffernan, on the 30th, is it your testimony that you first saw Eric that day at the hotel?
Yes.
And did you see him somewhere other than your room when you first saw him at the hotel?
I don't believe so.
So is it your best recollection that he showed up at your room and that's when you first saw him?
Yes, he called from the lobby, I believe.
And when he called from the lobby, was there some discussion about his inability to get a hotel room that night?
Yes.
And was that when you offered to let him share your room since you had two big queen-size beds?
Yes.
And did he then come upstairs?
Yes.
Shortly thereafter?
Yes.
And when he came upstairs, was this bodyguard person with him?
Yes.
Do you remember the name of this bodyguard?
No.
Did he ever introduce himself to you as a Detective Valentine?
I don't know that we were really introduced.
And did you, first of all, were you surprised to see this person?
Yes.
And did you question Eric about the presence of this person?
Yes.
What did you say?
Why is this person with you, Eric?
And how is Eric behaving about the bodyguard?
He didn't want him with him. He was a bit embarrassed.
Sustain the answers for
Did he say anything to you that led you to believe he didn't want him with him and was embarrassed?
He said it wasn't his idea, that Lyle was insisting that he be with him for his protection.
Okay, now that evening, do you recall what time it was when Eric and this bodyguard showed up at your hotel room?
It was late because we had gone to the night matches at the U.S. Open, and I believe they concluded about 11 p.m.
11 p.m.? So it was sometime after 11 p.m.?
Yes.
And I believe it's your testimony that you did not see Lyle Menendez and any girl with him that night.
No.
And had you seen Lyle Menendez that day?
No.
Had you seen him at the matches at the U.S. Open?
No.
Had you seen Eric at the U.S. Open that day?
No.
Was there any other young man in your hotel room when the bodyguard and Eric showed up?
No.
Was there anybody that you could conceivably have been mistaken by this bodyguard for Lyle and his girlfriend?
No.
It was just you and your husband?
Yes.
Now, the next morning, you said you woke up very early. Did Eric wake up at the same time you did?
Probably.
And did he then have this period of time when he was making phone calls?
Yes.
And after he completed making his phone calls, you and your husband and Eric and the bodyguard went to breakfast. Is
Yes.
that correct? And after breakfast, did you and your husband and Eric and the bodyguard get into a limousine and drive to the U.S. Open?
No.
You're sure of that, aren't you?
Yes.
In fact, your husband left breakfast before you finished to attend a seminar,
Yes.
and Eric left with the bodyguard,
Yes.
and you went shopping that day?
Yes.
Do you know, or did you know, Mrs. Heffernan, what time the day matches began at the U.S. Open that year?
We didn't attend the day matches, so I really don't know.
Have you been to other U.S. Opens?
No.
Did Eric pay you for the plane ticket?
Yes.
Do you have, this was on an American Express card, correct?
Yes.
And when American Express sends you a bill, do they also send you copies of the charge slips for the items that have been charged?
I think what I received was just it's not what Eric signed for, but printed. It says something like signature on file.
Okay.
There'll be 4 on a sheet.
So you've never seen any document that purports to bear Eric Menendez's signature for the purchase of this plane ticket. Is that correct?
No, I don't believe I have his signature.
Did you have any contact whatsoever with the limousine driver?
I never saw the limousine or the driver.
Okay. Did you know they were going to take a limousine?
No.
So the limousine wasn't mentioned at all?
No.
Mrs. Heffernan, are you on good relations with Eric Menendez?
I hope so.
And what do you think of him?
Objection irrelevant.
Sustained as to the form of the question.
You were called as a witness for the prosecution here. You understand that?
Yes.
Are you happy about that?
I didn't want to testify at all.
Okay. And let me go back to August 30th, August 31st. Could you describe, you had known Eric for some time by then, is that correct?
Yes, my husband had been teaching him for over a year.
And can you describe, to the extent that you could form an opinion about it, what his mental state seemed like that night and that morning?
Objection calls for speculation and proper opinion.
Sustained as to the form of the question.
Did he behave in a way that seemed distinctive to you that day?
I can't hear that.
Yeah, we have some, one of the bailiffs has his transmitter going too loud over there. If you can turn it down, please.
Alexa.
All right.
Exhausting. Okay. But let me ask you this. After Eric left, did you come upon things that didn't belong to you in your hotel room?
Yes.
What sorts of things?
His clothes, his shoes.
Left behind?
Yes.
Did he appear to be calm and thoughtful and fully rational when you were with him on the 30th and 31st, or did he seem some other way based on his behavior?
Sustained as to the form of the question.
Okay. How alert and aware of his surroundings did he appear on the 30th and 31st?
Objection calls for speculation.
Sustained.
Did Eric appear to be listening or hearing what was being said to him clearly? Was he responding appropriately to what was being said or done?
Objection calls for speculation and proper opinion.
Sustained. It's also a compound question.
Could you describe how he was acting?
He seemed dazed and preoccupied and not quite knowing what he was doing.
Objection, that's speculation. The motion is stricken.
All right, the last portion of the answer, not quite knowing what he was doing, is stricken as a speculation. The rest will remain.
Okay. Did he seem confused?
Objection calls for speculation.
Sustained. She's already answered the question.
And then you found possessions of his the next morning still in your hotel room?
Yes.
At that time, was Eric Menendez someone that you cared about?
Yes.
Why?
Objection irrelevant.
Sustained.
Do you care about him now?
Objection irrelevant.
Overruled. You can answer it yes or no.
Yes.
Why?
Objection irrelevant.
Sustained.
When your husband was coaching Eric, would Eric leave messages on your answering machine tape?
Objection beyond the scope.
Sustained.
Well, Your Honor, I would offer to call this witness back, but I'd ask leave to ask her these couple of questions.
How many?
2.
All right. Objection overruled. You can answer the question.
Well, 2 subjects. It may take 3 or 4 questions, depending on the objections, et cetera.
Depending on the questions, et cetera. Okay.
Well,
Yeah.
same difference.
Okay. Do you understand the question?
Yeah, I asked her, would he leave messages on the telephone answering machine?
Yes.
What kinds
he
of
would.
messages stand out in your mind?
He would use it.
This calls for hearsay.
Sustained.
I'm not asking the content. I asked the kind of messages.
It's irrelevant.
I don't believe so, Your Honor. I can make an offer.
Well, go on to the next question. And at this point, her characterization is irrelevant.
But would he leave long, detailed explanations of tennis matches?
Yes.
Would he use up your whole telephone answering tape with these detailed explanations of his matches?
Yes.
Play by play?
Play by play.
And when you knew Eric in 1989, did he appear to be an aggressive or a hostile or a loud person?
No.
Would you describe him?
Is that a question?
Can you describe?
Objection sustained to the form of the question.
Would you please describe why he wasn't that way? How was he?
He was very.
Calls for improper opinion.
It's vague what you're asking.
Okay. I asked you, was he an aggressive person?
Not to me, no.
What word would you use to characterize him?
He was very.
Objection improper opinion.
Sustained.
Oh, Your Honor, I'd like to be heard. Okay.
All right.
Mrs. Heffernan, I want to call your attention to that breakfast at the Sheraton Hotel. Do you remember whether or not the U.S. Open was discussed at breakfast in front of the bodyguard?
I can't recall, but I'm sure that it was. I'm sure we talked about the various matches that week.
You weren't at any matches that week, though, with Eric Menendez, were you?
Not with Eric, no.
Do you recall if there was any discussion about any female players or female player matches?
No.
Mrs. Heffernan, have you watched parts of the trial on television?
Yes.
Did you see the testimony of Mr. Valentine last week?
No, I didn't.
I have nothing further, Your Honor.
Any redirect?
No, no.
All right. Thank you. You may step down. You're excused. And is that all for the blue jury?
Yes, Your Honor.
All right, then, ladies and gentlemen, we'll excuse you until Monday at 9 o'clock. Hopefully, we'll start promptly at 9, so we'd ask that you all get here a little before then so that when everybody is here, we'll proceed. The lawyers and I will be here this afternoon going through any matters that we have to resolve before the next witnesses testify, so that hopefully there won't be anything that will prevent us from starting at 9 o'clock. And again, don't discuss the matter with anyone. Don't form any final opinions about it. At 9 o'clock, have a happy Thanksgiving.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
Regarding this afternoon, how long do you think it'll take to discuss Ms. Eisenberg's testimony?
Eisenberg's testimony? Yes.
Half an hour.
Okay, and then are there any other matters that have to be discussed in relationship to the testimony of Mr. Anderson or any other of the people's rebuttal witnesses?
We went over all that. We've gone over all that. I guess it depends on whether we're given discovery of what they're likely to say.
Oh, I did ask Mrs. Farrell if she had seen specific instances where Lyle and his father had these discussions which ended in hugs, and she said she can remember 2 such instances which occurred in the house, and that one of them she viewed from afar, one of the happenings closer to where she could hear the tenor.
All right, so what we'll do is at 1:45, I have a meeting, so we'll resume at 1:45 and deal with Ms. Eisenberg, and I'd like to get a start on exhibits here so that we don't have hearings that interfere with beginning of argument relating to exhibits. So I know council have gone through and isolated those things that are in dispute. If you care to do any more of that before the hearing, that would be fine. I know you've given me a list of objections.
That does not include the last whole bunch of the topics.
Yeah, I understand that, but as I recall, many of these are just objections that are made to preserve the record and have already been discussed at the time the exhibits were utilized. Is that correct?
Yes.
So there really won't be an extensive argument. If you could isolate for me those things that are really going to be subjects of controversy, it would help. If these are just pro forma objections to preserve the record, we can expedite that and go on. And as far as the defendants, do you want them here for this hearing? I assume you do, since it relates to receipt of exhibits.
Yeah, if you're going to rule, it should be.
Well, I certainly hope to deal with as many as we can get to. Those that, as I said, are just pro forma preserving of the record. We can skip through those rather quickly and get to those that are really in dispute.
Are we working to 5 or to 4:30 or to 4?
Well, I don't intend to keep the court staff here. We'll be here until 5, so we'll try to expedite this. But the quicker you can identify those things that are really in dispute and we can get to them, I think it would be better for everybody. All right, we'll resume at 1:45.
Front door, so I stepped back and was standing near the windows, and I looked over and I saw a witness, I believe to be Karen Farrell, and a tall man that I believe to be her husband. Were each, Karen Farrell hugged both Detective Zoller and Miss Plazanich, and then Karen Farrell and turned around and hugged Marzi Eisenberg, who is the next witness, and then they all headed towards the elevators.
A lot of hugging going on in the hallway, huh?
It's a huggy-muggy sort of hallway.
All right.
And yes, that it didn't occur, Your Honor. She approached me and hugged me before I could do anything. And I looked over and saw that the jurors were not facing in the direction. They weren't looking at us. And then she went off and did what she did. And I didn't have any. I was the first person she grabbed. So I looked over to make sure, to see if any jurors were watching. And I noticed that there were some jurors there, but they were quite a distance away and they weren't looking in the direction. So I wasn't even really thinking, I didn't really think I should slap her.
All right.
I will say that it wasn't the prosecution initiated hug. However, it did occur, and it occurred in the presence of certainly 2, perhaps more of the blue jurors in this case.
And what did you want me to do?
Well, that's a good question. We could ask them what they, if they saw anything.
And if they did, so what would you want me to do?
Prohibit the witnesses from testifying.
All right, and if counsel in the courtroom or in the hallway, other times have had physical contact with participants in the trial in one form or another, should I prohibit any participation of those individuals, or what should I do in that regard?
Are you talking about the defendants or other people?
Anybody? Oh, it hasn't happened. Okay. Well, I don't see any reason to do anything at this point. I haven't heard of anything that's prejudicial. It doesn't require, from what you presented to me, any further action by the court.
Well, the only thing is, Your Honor, we're not requiring action by the court, but we intend to question the witness, Karen Farrell, about her hugging the prosecutor and the investigating officer as bias.
You certainly can do that if you choose.
Now the court will know what it is we're talking about.
That's fine. Okay, anything else? All right, then let's proceed with Ms. Eisenberg then. That's the next potential witness. You provided me with various proposed or various statements of hers that's, I don't think any of it's been highlighted, or maybe some has.
Well, you're starting at page 16. There should be highlights in the first copy.
Yes.
Okay.
Well, the kind of our counsel is counsel going to rely on anything that appears in earlier interviews without witness, parole interviews in the earlier police interview, or from what's repeated in counsel's notes, or other things that you did not read interview on.
Can we go ahead and go through this part first, and I'll sort of skim through these two reports that I have?
Well, I want you to participate in this, so I want you to be doing something else at the same time we're talking about this.
All right, well,
So on page 16, the highlighted matters are things that are being submitted by the prosecution, is that right?
yes.
And what is their objective to by the defense? Page 16. Okay, is there any objection to page 16?
Yeah, Your Honor, I obviously don't have a properly highlighted copy. I've been going off on a long section.
All right, we'll take. Well, no, if,
I don't have the right copy.
well, why don't you get it so that we don't have to go back on matters that, okay, let's take a break and Ms. Abramson will then go through it and highlight the material so that we both will all have the same material. Take a short recess and then we'll resume. Right back on the record regarding the proposed testimony of Eisenberg. Page 16, were there any objections?
Yes. Oh, page 16. No, not the page 16.
Mr. Burt?
No. Judge, we're stating the objections jointly unless we indicate otherwise.
Okay, that's fine. Page 17.
Yes, we object to the business about Jose writing the letter and what the letter said as hearsay. Really not the best evidence. We don't have this letter. Additionally, Eric Menendez, but it's being offered apparently to show in a way that's totally non-cross-examinable what Mr. Menendez wanted or said in this letter.
It's apparently represented in the notes as a letter that was then read by the defendant, Lyle Menendez, at some eulogy for his father at Princeton. Is that what it says?
Yes, Your Honor. That Ms. Eisenberg read the letter at the time that she found it on Mr. Menendez's desk, and she put it in a file for Lyle Menendez, and that she recognized the words from the letter when she attended the eulogy and heard him speak.
And did you propose that she recite the contents of the letter, or just say that he read a letter that, or used the words that were in a letter that his father had written to him?
Well, she can't recite the contents. She can only recite that the letter conveyed to the defendant that the father wanted him to be a good person and that he loved him, and that these words and that she recognized it by content at the time of the eulogy, that she recognized the formation of the words, and she recognized it as being something she had read in Mr. Menendez's office.
And as far as the argument that the best evidence is the letter itself, what is your response?
Well, Your Honor, in that it appears that the defendant, Lau Menendez, circumstantially must have had that letter. Since people, through no fault of their own, can't get the best evidence, I think the best evidence will live with five. It's only if we destroyed it that I think there'd be a problem.
What is the defendant's response that the defendant had possession of it, therefore people cannot provide anything other than a secondary source?
Well, but is that really true? The problem is the witness cannot recite line for line this letter. She could not say with any reliability. I mean, if she tried to, it wouldn't be believable, but she knew absolutely it was the identical letter.
Well, you're saying these things, but I'm asking the defendant, Lau Menendez's counsel, what is your response? In good faith, are you saying that the prosecution has this letter? Or should have it, or has access to it, or are you saying that the defendant had it?
We don't have it.
We don't have it. If we had it,
I don't.
When you say we, you mean the defendant doesn't have it, never had
Defense
it?
doesn't,
we don't.
the defense team does not have it. The defense team has never seen the letter. Ever.
Regardless of the defense team, as a defendant, did the defendant have possession of it at some point, and was the last person to have possession of it?
No, the last person to have possession of it, from what we understand, was Maria Menendez. And she has never cooperated with us in the obtaining of letters. Oh, well, there's a dispute even about whether this is the same letter that Mr. Menendez read at the eulogy. As an offer of proof, Lau Menendez would say that the letter, he's never seen this letter that she's talking about. A letter written. And the reason that we offer that is that Lau Menendez would say that he does not recall ever having a letter written by his father shortly after the grandfather's death, which is how Ms. Eisenberg is identifying this.
Well, Ms. Eisenberg replaced the writing of the letter and her discovery of the letter as something that occurred shortly after the death of the maternal grandfather of Lau Menendez, but that she put it in a file. So I don't know that his grandfather's death is when around the time when she discovered the letter, but that doesn't, I think, mean that's when Mr. Menendez got the letter.
Which our information is that the grandfather died in 1987, so an additional objection to this would be remoteness under section 352.
And one would assume that from what we've heard about Jose Menendez, if he wrote two letters to his son, they would tend to have the same kind of rote language. He seems to be a person who repeated himself a lot.
Well, that's all well and good. You can argue to the jury, but that doesn't help me ruling on this matter.
But I'm saying it's not reliable information. She's saying there was a letter and she thinks the same letter is read. And how do we cross-examine about that? We have no letter. Our client has no such letter.
All right, number one, is a prosecution representing that this particular letter that this witness would refer to was actually received by the defendant? Can you establish that as a foundation, number one?
Yes, I believe she can testify that there were files in Mr. Menendez's office, Lyle, Eric, and things like that, and that she relayed those to the defendants after their parents' deaths.
She did what?
She gave them the files to the defendants. I will check with her, I will double check with her, but that was because I remember asking her about how Lyle Menendez would have gotten this letter that was in the file, and I believe she indicated that she gave the files to the defendants after their parents' deaths.
Information we have is that Martha Connell had actually gone to the office and gone through files. Now, Martha Connell can testify about such a letter, but there's been no testimony that the defendants went before the trip to Princeton to the offices and removed anything.
Well, it's not so much if there has been testimony, it's a question of will there be such testimony that this occurred? And again, if the people have the burden to, number one, establish that the defendant received the letter, either by direct evidence that it was given to the defendant by the witness or circumstantially that he read and quoted from the exact document that this witness refers to in this particular statement. And is there some representation that the defendant indicated he was quoting from a letter his father had written, or he just used words that were similar to those that his father had written?
She indicated, and it's here in my notes, he read or repeated the contents of the letter at the eulogy. And I think that Glenn Stevens indicated in his testimony that that he had read a letter from his father.
Well, so, I mean, is it something where he was standing up there and saying, "Now I want to read my father's words in a letter he wrote to me, and these are what he said. These are the words he said."
Miss Eisenberg's best recollection is either that he read it or he repeated the contents of the letter. That's what she told me.
Well, it's obviously a difference if he repeated the contents, and then she has to remember back to what was said in the letter and say it was the same that he said versus the defendant's own words saying he's quoting from his father's letter.
Well, but Your Honor, the defense argument would be that even if he read from it, there's no guarantee that that was the exact same letter unless she could identify it sitting in the audience and say, yes, that's the same letter because I can tell because of the paper or something. I think what's significant here is that the defendant adopted the sentiments of his father, which she had read in a letter, which we don't have in our possession under 1505 of the evidence code. We are not bound to produce it. That he had given these sentiments in 1987, shortly after the death of his father, and they were repeated by Lyle Menendez at a service at which he repeated the same sentiments that Miss Eisenberg had read 2 years ago. I think that's what's significant about it, is that she can, if in fact, let's assume that she says, I went to the memorial service and Lyle Menendez read from a letter or repeated what he said were the contents of a letter in which his father expressed love for him and other things. All right. I think that's relevant to show Lyle Menendez's state of mind as it differs from the theory of the defense as to why this murder occurs.
All right.
Then
you
to go the next.
Prove that, number one, by somebody who was at the memorial service.
Which she was.
Okay. And she can say, this is what he said.
Right. And then the next step of that is that, and as a matter of fact, in 1987, I read a letter which was strikingly similar in sentiment to that which was referred to by Lyle Menendez in his memorial speech, which was written by Jose Menendez, which I put into a file for him.
I think that's where you have confrontation problems, though, Your Honor, and reliability problems. And beyond that, from what I'm reading here, I don't see how this is proper rebuttal. I don't recall Lyle Menendez testifying that in his own way his father didn't love him. In fact, I think Lyle Menendez testified that he was the most important thing in the world to his father, nor that his father wanted him to be a good person. I don't think this is proper rebuttal.
Well, one would have to look throughout the entire defense case, which was presented over an extended period of time, and look at all that was presented and make that determination. And there certainly was reference to different occasions when the defendant, one or the other, spoke at memorial services for the parents. I don't think this particular memorial service was referred to, but others have been referred to during the either direct or cross-examination of the defendants. Other statements have been attributed to the defendants relating to their attitude towards their parents. So I'm not so convinced that the defense position is accurate, that this is not proper rebuttal based upon all that was presented by the defense during its entire case. But the second portion of the prosecution's offer would have to be buttressed by something more than the representations made here. I don't think that people have a clear idea exactly what this witness would say.
Rehearsed 3 times.
I've already said that I don't feel that people have made a sufficient showing. And let's, if we can, cut back on side remarks that really don't have any bearing on our hearing here. The editorial comments don't really help me at all. They just distract from the proceedings. All right, what else is being objected to on page 17?
No, Your Honor, there's 2 aspects then to the...
Make your notes, and what else is being objected to on page 17?
The bottom where it says Marzi liked her, meaning Kitty. She was warm, sweet, thoughtful, sent flowers. That's irrelevant how Marzi felt about it or how she treated Marzi. And I was stopped from asking Mrs. Heffernan today how she felt about Eric Menendez. I don't think the people should be able to simply put on other people who like Mrs. Menendez for their relationships with her.
Well, as far as any bias is concerned, that one way or another, that's about as far as it could go. I don't think any extensive feelings one way or another or characterizations is of any significance. But if there's some bias one way or the other, then it could come out.
Well, I was trying to elicit from Pat Heffernan that she thought Eric was sweet and tender and kind.
No, that's not what I'm talking about. Do you like or dislike somebody? Not characterizing their personality in some way. Just did you feel kindly towards someone or did you not?
Okay, so the warm, sweet, thoughtful, and sending flowers part, I take it, is going too far.
I don't see how that has any bearing on this, if it unless the people want to be heard as to what is the relevance of it. Page 18. Is there any objection?
Yes, we would object, first of all, to the conclusion or opinion of the witness that Kitty spoke, quote, fondly of the boys. I don't know what that means in its conclusionary language.
People wish to be heard?
Yes, Your Honor, the gist of the defense case is that Mrs. Menendez views her sons as nothing more than an extension of her own self-aggrandizement. And I think that if she spoke of her children in terms of fondness, that would counteract the picture that's been portrayed by the defense of her as not. In fact, I believe that even Dr. Cox was allowed to testify that Mrs. Menendez's children were objects to her. And I think that this counteracts that particular thrust of the defense case.
Well, as we've seen in the testimony of Mr. Anderson, without something specific, it's difficult for the jury to understand what is being referred to when somebody makes rather broad statements such as this. So if there is something specific that can be described by the witness, certainly that doesn't have to pin down a date or incident, but that she personally observed certain things that would be more helpful, or she heard certain things than just the generalities of what is expressed here. But again, if she would say that Mrs. Menendez always spoke in positive terms about the defendants, that would be admissible. But if she says something or describing in what would be meant by that, but just the description here would be rather difficult to justify in the way it's expressed here. You have to be a little more specific. But if there is testimony that she always did something a certain way, she never did anything another way, then perhaps that would be sufficient. All right, what's the next objection?
The fact that Lyle charged flowers twice on the company's American Express card, and he wasn't supposed to use the company credit card. Under 352-1101 personal knowledge grounds, I think both of those statements should be kept down.
Any information by the prosecution if this witness had firsthand knowledge?
She was the one who reviewed the American Express bills, and she was the one that, in fact, it says there, right there, and she made Kitty pay for them in New York, which is that she went over the bills and scrutinized them for charges, and she is the one who actually found these particular things, and she indicates that Lyle Menendez did not have consent to use the company credit card.
How does she identify that these were his expenditures?
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
That I can't represent to the court. I didn't ask her how she knew they weren't his. I'm assuming she had conversation with either Mr. or Mrs. Menendez, but I didn't ask her specifically how she knew.
Even if you assume this is true, however, this refers to a time when they lived in New York. That's when they were working in New York. That's 1986. What difference does it make if Lyle Menendez charged flowers, even improperly, against the company credit card? Isn't that 1101 evidence of dubious probative value? And
I don't regard this as 1101 evidence. It's rebuttal to whatever the defense has introduced.
Well, the
If
defense
there
hasn't
has been any evidence that would justify this rebuttal, what is it being offered for?
Your Honor, I believe that the tenor of the defense has been that Lyle Menendez had all the credit cards and all the money he needed. There have been witnesses who've testified to the contrary. I think Donovan Goodrow initially even said that he didn't have free use of the credit cards. However, shortly after his parents' demise, we know that Mr. Menendez charged the Rolex watches on the company credit card. And so I think that this shows that he did not have the $250,000 line of credit prior to the death of his parents.
How does this show that?
Because he wasn't supposed to use the company credit card.
Who says, well, come on, let's not have these little discussions. If you have something to say, wait until one side is finished, wait till I've asked the question, you can respond. How do you know that this wasn't authorized? How do you know it?
Because
what the credit limit was?
How do I know what the credit limit
Yeah.
was? Because Ms. Mahar testified to it. She said that.
No, I'm talking about this particular transaction. You're offering this to refute something that's been offered by the defense.
Yes, which is the idea that he had unlimited access to unlimited credit cards and unlimited funds, and therefore he would never have killed his parents for financial gain. I believe that is the tenor of the defense that's been presented. And this would be to counteract that Ms. Eisenberg was not only his secretary, but she was a personal, like many secretaries, she did more than just type. And one of the things she was aware of is Mr. Menendez's credit cards and what was and wasn't supposed to be on them. And that Lyle Menendez was not supposed to use the company credit card.
Your Honor, one of the difficulties with this is, and she's talking about flowers in 1986 when they're living in New York.
Well,
versus whether he was authorized to use the credit card in 1989. And I believe it was the people's witness, Ms. Mahar, who indicated she called American Express and found out that he was authorized to use the credit card. So I'm not sure how that works as a vehicle for admissibility for the prosecution.
Your Honor, I would withdraw the flowers being charged twice in New York. However, as far as whether or not Lyle Menendez was authorized to use the credit card, which was the credit card which Mr. Menendez had at Live, I think she has personal knowledge. After the homicides, it's my understanding that after the homicide, she wanted to cut off the credit card, and the company said no. She wanted to close the account.
What does that have to do with her statement?
Because before the homicides, Lyle Menendez was not authorized to use the company credit card.
How does she know that?
Because she was Mr. Menendez's personal assistant, and she just knew it. It was part of her job. It's
that's good.
Well, but Your Honor, it's kind of like saying, how do you know how to type? Well, I just learned how to type. I mean, it seems to me that there's certain kind of knowledge that you acquire that you can't really point to the source, but because of your job and your exposure and everything, you just know it.
All right, but that doesn't make it admissible evidence.
Well, but Your Honor, that's like saying, how do you know this table is a table? Well, I just have always known that something that looks like this is a table. I mean, we're getting into now the distinction between how you know things specifically and generally. And she was.
This is rumor, hearsay, or whatever else. It doesn't make it admissible evidence. Just because she says she knew it doesn't make it. Number one, doesn't make it true, and number two, doesn't establish that she had firsthand knowledge of it. Someone told her that, and whether that person was telling her the truth or accurate information is anyone's guess. Unless she herself was the person who made the decisions as to who was and was not authorized to use the credit card.
It's my understanding she carried out the decision as to who was to use the credit card.
Whose decision?
The decision of the company and Mr. Menendez.
Well, there are two different things here. Mr. Menendez was using the company credit card also, I suppose. And did somebody at the company give him authorization to use it? Did they give him authorization to authorize other people to use it? Did they authorize other people in his family to use it? I don't know those things, and I doubt if she does. But even if she does, she doesn't is not the one who made those decisions. So at this point, the court is going to sustain the objection to that, unless there is some foundation established as to how she would know this. Page 19.
The rest that is highlighted, this statement by Lyle Menendez, supposedly made to the witness in a limo on the way to the Bel Air after the memorial service. From the Eric Menendez perspective, we object to this coming in against Eric Menendez.
Okay, then
but
you said
more-
all you have to say then. It's only
No, I'm
offered
also-
as to the defendant Lyle Menendez, is that right?
Yes, Your Honor.
Okay, then what is the position of Lyle Menendez?
Our objection, Your Honor, is that this is irrelevant and it's also improper rebuttal because it's a statement that was available to the people in its case in chief, and for whatever reason, the people didn't put this evidence in. Furthermore, it's not appropriate for any issue raised by the defendant's case.
All right, what is your response?
Well, first of all, Your Honor, this is information which the defense knows is not contained in a police report. And the first time I interviewed Ms. Eisenberg was on Sunday. So this is new information from Ms. Eisenberg. And as far as it being probative, we're talking about an event that occurred on August 25th after the Los Angeles memorial service. I think there's no dispute that that was the date of the service. It shows, I think it's corroborative of Glenn Stevens, where Mr. Stevens testifies that Mr. Menendez told him in Princeton, I've been waiting all my life for this position. It also shows it certainly shows a callousness and a lack of sensitivity, which I think the defense has tried to portray as to Mr. Menendez and the feelings he had towards his parents' deaths. And it also shows that he desired to fill his father's shoes rather than desiring to kill out of fear.
I don't quite understand the line says you don't understand, these are my father's shoes.
He was wearing his father's shoes. He was actually wearing his father's shoes.
All right, and then what's written below that?
Then he looked at his cousin Carlos Menendez and started to discuss the U.S. Open and whether they could get tickets for it, which we now know was the following weekend.
All right, and this was on August 25th after the memorial service?
Yes, they were traveling in a limousine to the Bel Air Hotel after the memorial service. And she had this conversation. It was in the presence of Eric Menendez, who I believe she described as looking out the window at the time it was said.
Oh, I can see that that's written here, can't you, Your Honor?
Well, if it's not offered against Eric Menendez, what does it matter?
Well, it might be nice for Lyle Menendez's team to know that Eric might have been.
Okay, well, you don't have any say in the matter as far as it being offered as to Lyle Menendez, so just keep quiet. Let's hear what the objection is by Lyle Menendez.
To the extent she says this evidence is corroborative of Mr. Stevens, I think it highlights the fact that this evidence, if admissible at all, should have been offered in the case in chief. It's a statement that obviously makes Lyle Menendez look callous, as she indicates. That's the purpose for which it's being offered.
All right, they said he didn't know it until a couple days ago.
Your Honor, may I speak to that? Ms. Eisenberg has never been available to us to be interviewed. She was available to the prosecution early on and frequently. We have a number of phone messages between her and Detective Zoller. She's referred to at one point as the liaison between Live and the police department. She's been on their witness list. They've had constant contact with her. So I don't think that they can just fail to interview someone for a substantial period of time and then go back and get information. Before she was interviewed by Mrs. Bazanich on Sunday, I think there were two statements that they were going to use her for. One is the shower, and I can't remember what the second one was, but there were two very discrete areas on which she was going to testify. And so I think that they have merely failed to interview her. It's not that she wasn't available or this was material that couldn't have been discovered. It just wasn't, and that's a way for them to sandbag, to protect it. Just hold back some witnesses and interview them later. I don't think that excuses attempting to put it on at this point in
Also,
time.
as a 352 matter, Your Honor, the circumstances under which this statement surfaced at the last moment, I think if the court allows it, and it is damaging, it forces the defendants or the defendant Lyle Menendez to go back in time to the first interview, which was in August of 1989, to indicate that she was questioned at that time, never indicated this statement. She was questioned again in September. There are numerous contacts between her and Detective Zoller, up to and including this last contact with Ms. Bazanich. So the defense, I think, is put in the position because, and the court was critical of the defense for doing this, interviewing witnesses, taking statements and putting counsel in the role of witness. I think it forces us to put Ms. Bazanich in the role of examining her on the circumstances under which the statement was made. And I think that's an unfair advantage given the kind of statement that we have here and the position it puts us in terms of trying to show that after all this contact and these many years, 4 years later, she comes up with this bit of information at a crucial point in the trial.
All right.
Detective Zoller was present, right?
Okay.
You just can't read his hand.
Well, these are not Detective Zoller's notes.
No, not hers.
Well,
And in fact, Detective Zoller doesn't have this conversation in
Right, in
his
his
notes. Ms. Pazanich does, and I think that would be probative.
wait, it's right here. It's right here at page 6. After deaths, Lyle was something his father, after memorial service, held up feet. Marzi, who said I couldn't fill my father's shoes. No, these are my father's shoes. Wore Rolex watch for service. It's right here on page 6 of his notes.
Right, which differs from the statement that Ms. Pazanich has in her notes, which creates a conflict as to exactly what was said.
Okay, that's a far cry from what I referred to when the defense counsel by themselves, without any third party present, conducted interviews and created the situation of impeachment of witnesses when those statements were turned over to the other side, and the difficulty of impeaching witnesses without calling the person who conducted the interview as a witness. But here there was someone else present. So the fact that she's written something down to give to you doesn't alter the fact there was another witness present. So that's not the issue that concerns me. There is the argument by the defense that there has been delay by the prosecution, and the allusion is that this was deliberately done to wait until after the defense has presented its case to come up with information to utilize during rebuttal. Number one, I assume that the defense is arguing this was intentionally done, that the prosecution intentionally did this with the idea in mind to get this information. Is that your position?
I don't think the issue is whether it's intentional or not. I think that it's a witness who was available to them. They had a duty to interview her. They clearly were talking to her about circumstances surrounding the killing of the parents, the relationship of the sons. There are statements in that regard from her early on. And I think that they have an obligation to interview their witnesses and present the material in the appropriate time frame, and to merely negligently or intentionally, either one, delay to do that work and then try to put it on at the end of the case after the defense has already put on their witnesses. I just don't think it's permissible under the law. And I don't think it's a question of whether it's intentional. If it's intentional, it's obviously more egregious. But I think if it's even negligently done, if they fail to discover the appropriate evidence that was available to them, I think that is their problem and shouldn't be ours.
Okay, well, that's not the law. So let's not get off into some creation of new areas of law that don't exist. Yes.
I just wanted to add, Your Honor, that this statement really I don't think can be isolated from the other statement, which has to do with Lyle Menendez being in the shower, because this was a situation where the prosecution disclosed to us a defense interview with Marzi Eisenberg, which took place on December 11th, 1989. The subject of that interview was statements that she heard following the killing made by Lyle Menendez. And that interview was a basis for the people's offer of proof in their case in chief, asking the court to admit this statement concerning what she heard after the killing. They abandoned that theory after the court ruled that evidence would be admissible. The defense then goes ahead and puts the defendants on the stand and obviously does not allude to the statement because it's not in front of the jury.
You're saying that was a statement in a defense interview with Ms. Eisenberg?
No, it was a statement in if I said that, I was in error. It's an interview by Detective Zoller in which Marzi Eisenberg called up Detective Zoller in December of 1989. And after being interviewed by investigators from Live Entertainment, she claims to have remembered a conversation she had with Lyle Menendez after the killing. And that statement concerning Lyle Menendez being in the shower is offered as part of the prosecution's motion in limine. The court ruled it admissible.
I don't recall ruling on that, quite frankly.
You did. And you ruled it admissible. Mm-hmm. And the prosecution abandoned its desire to put that in front of the jury.
That was ruled upon in relationship to What issue? Prior to the trial?
Yes, the making of false statements on a consciousness of guilt theory.
That specific statement
Yes.
was ruled upon?
Yes, it was.
Okay.
And then the defendant testifies and, of course, does not address these statements because the prosecution abandoned its desire to put the evidence on. And now we're in a position at the very end of the trial of having to rebut two very damaging statements by putting Lyle Menendez back on to deal with these statements. And that, I think, comes within the rebuttal rules, that it's unfair advantage to allow the people to highlight incriminating statements, whether they be a confession or not, at the very end of the case to give them a tactical advantage and to force the defense then to put the defendants back on to explain a statement which could have been explained while they were on the stand, but because of the people's withholding of these statements, puts us at the unfair advantage of having to highlight this damaging piece of information at the very end of the case. And in any event, the only thing the statement proves, I think, the statement concerning having his father's shoes on, at most you could say about this statement is it shows a lack of remorse post-crime. And lack of remorse after the crime is not relevant to state of mind, and it's certainly not relevant rebuttal.
All right, we've had a great deal of evidence relating to the defendant's demeanor and behavior immediately after the killing of the parents, and including the time frame that would be encompassed by August the 25th.
Well, that's true, and I think the thrust of the testimony was that they did play the role of aggrieved sons. They did lie to the relatives and others, and the specific lies they made were brought before the jury in many different forms. There was no claim of Lyle Menendez while testifying that he was not playing the role of bereaved son or that he was doing something other than what the prosecution claimed he was doing. And now this evidence is brought in to give the jury a final dose of false statements on an issue that really wasn't disputed by the defense.
All right, well, as far as this August 25th conversation in the limousine, it does appear to be rebuttal to the type of evidence that's been introduced by the defense relating to the defendant's demeanor and behavior. And there has been no showing that the prosecution knew of this prior to the date of the interview of November the 21st, 1993. And no showing that the prosecution deliberately failed to obtain this information until this stage of the proceedings, and therefore I find it's proper rebuttal evidence, and there is no impropriety in it being used at this time under these circumstances. It's being offered only as to the defendant Lyle Menendez. As far as the related conversation, we'll get to that a little later on. If you could, first of all, is it the people's recollection as well that this was something that you had offered and the court ruled upon prior to the trial?
Your Honor, it is definitely in the motion I filed on March the 15th. But my recollection is that when we finally got to going through the motion item by item, that I said that we weren't going to offer her in our case in chief. So I don't recall that there has been a ruling. And I'd like to, in fact, I have a log here I'm checking right now to try to figure out when we finally did that with the motion.
Okay, well, you can find that. There were many issues that the court indicated it would not rule upon prior to trial. There was many matters that the parties sought rulings on, as far as little bits and pieces of evidence, testimony of each and every witness that the court did not feel would be appropriate to rule upon prior to the trial, that these are matters normally handled during the trial, and I don't recall specifically ruling upon this one. If you can find it in the record, you can certainly identify that, and if there has been reliance upon it by the defense, then we can discuss it further.
I think the point here with respect to that is, I think the court did rule on it, first of all, generically.
Fine.
Saying that consciousness of guilt.
I mean, in general, not that specific statement.
I don't know if the court said this specific statement, but my recollection of the procedure was that people offered various false statements on a consciousness of guilt theory. We took the position that was not relevant because identity was not disputed. The court rejected that position, which left the prosecution free to come forward with any false statements they had. They at that point said, this particular statement we're not going to offer, but regardless of whether
They actually said that prior to trial, that we will not offer this statement?
Yes, regardless of whether the court ruled or not, the fact that they identified that in their motion in limine as relevant to their case in chief, I think illustrates that this is improper rebuttal, that they themselves knew at that point that it was something that should have been offered in their case in chief. And as a matter of tactics, they held it back and it wasn't held back because the court ruled it inadmissible. That I do know. The court never said this statement may be admissible in rebuttal, but it's not admissible now. At best, the court may have not specifically referred to the statement, but they never pressed for a ruling, and they themselves came forward with a statement as an item of evidence admissible in their case in chief.
Okay, as I said, I don't recall ruling on that specific statement related by Ms. Eisenberg, one way or the other. That's the first issue. Now the defense's position is that it was a ruling in general about any statement of the defendants that were made falsely, that the defense position is that each and every false statement of the defendants had to be introduced by the people in their case in chief, even though the defendants have since testified in their own defense. And your position is that people cannot offer anything else in rebuttal to their testimony in regards to other false statements they made. Is that your position?
No, I think the court has stated the position too broadly. Our position is when the people themselves come forward with a particular piece of evidence and identify it as admissible in their case in chief, and without any restriction by the court, they hold that evidence back, that particular piece of evidence is not proper rebuttal under the rules, which say that they cannot hold back pieces of incriminating statements and then introduce them late in the trial on a theory that they could have used during their case in chief. And in fact, they did use for other statements. Not that each and every statement that they could discover or that was not in contemplation of their case in chief could never be admissible in rebuttal. I think that's too broad the way the court framed it.
Well, as I understood from an offer yesterday or earlier when this was discussed, the people, and I know the defense position was that this was their real purpose in bringing it out, and why you objected to it was that it somehow fit in with some other evidence that's been received during the defense case relating to taking a shower or something of that nature after the killing of the parents. And that's really why the prosecution is seeking to introduce it now. If that's true, then haven't they now focused on a reason to introduce it that you've articulated that they didn't have prior to the trial?
I was the one who made that argument, Your Honor. It had to do, we were talking about Judalon Smith testified that when she said something about them taking a shower, it was pure speculation on her part because she figured out if it had been so bloody, they would have gotten blood on them. And so she told the police. In the course of her telling the police this theory, she's telling them she's speculating. So
well, also bear in mind,
stretching it.
Well, you're the one who offered it as a position that you thought was why
We didn't
people were
offer
offering
it for the truth. We offered to show she was speculating.
Yeah. Okay, but let me go one step further in response to Mr. Burt, or inquiry of Mr. Burt. The people obviously are now in a different position, as is the defense, now that they've heard the defendant's testimony.
Yes.
They did not know what the defendant's testimony was until they testified. So aren't they entitled to introduce things that could impeach their testimony that they didn't want to introduce before?
On the theory that this statement shows that he in fact was taking a shower after the homicide?
That either that or that he lied about it, an additional lie or a contradiction to his testimony in the trial here. This is a prior statement of his. Inconsistent statement can be used for whatever purpose the jury wants to use it.
I have trouble reconciling the lying theory with all the evidence they did put in under consciousness of guilt, because They articulated for the court that although identity was an issue, state of mind was, and false statements such as the September 17th statement, the August 21st statement, and several other statements, the mafia statements, were all relevant on a consciousness of guilt lying theory. That was their theory going into the case in chief. The new theory is I would concede to the court different. That is that this statement now becomes relevant because it proves that they took a shower after the crime. If that's what the statement shows, then that might be a proper rebuttal theory. The problem I have with that is that in the interview with Miss Eisenberg, Detective Zoller, in the last pages of the report, says that Lyle said, "I was in the shower. I don't know why I didn't hear anything." I.O., meaning Zoller, asked Eisenberg what time Lyle was referring to being in the shower. She said during the murder. So I think the statement is clear that she is saying that he was in the shower during the murder. And that then is relevant only to a consciousness of guilt falsehood theory. I don't see how that statement is probative of showing that he took a shower after the killing.
All right, what is the people's response to this colloquy, if any?
Well, Your Honor, I'd just like to point out that on March 15th, when we filed the motion to admit the evidence, it was one of the first motions filed, and we still had pending before the court at 1538.5, which might have excluded Dr. Oziel altogether. If that had happened, the people would have had to resort to other means to prove identity. In the meantime, the defense conceded identity and tried the case on other theories. So I'd just like to point out, because it was in the motion on March the 15th, there were many issues left to be resolved as to how the case is going to be tried. As to this particular statement, it's the people's theory that shortly after the murders that the defendants did return to the guest house. Officer Butkus testified, I believe, that the guest house was open and the lights were on, the front door was open. And Dr. Burgess testified that whoever had done the killings would have had blood all over them. And Sergeant Edmonds testified that there was nothing remarkable or noticeable about the defendant's clothes or their persons when he interviewed them. So it's the people's theory that when Lyle Menendez said he took a shower, he's correct. It's just he wasn't going to tell Ms. Eisenberg he took a shower after he killed his parents, certainly. And that this is a statement, it's similar to the statement of there was smoke in the room when we came home. We know now that the smoke was when they did the crime, but the smoke is something that stuck with them that indicates that they were the ones that did the crime. When Mr. Menendez talks about the shower, it's the people's. I intend to argue that, in fact, he did take a shower, that they immediately retreated to the guest house, and that this was an alibi that was going to be offered in case they got caught in the guest house when the police arrived, and they could say that, well, we were out here, we didn't hear anything, and it's being offered for that particular purpose, especially in light of the fact that the defendants testified that after the murders they came up with this idea that they had to get rid of evidence and they had to travel all these different ways, that this is in fact what happened and not what the defendants said what happened.
Okay, does someone have the original report that Detective Zoller obtained?
And that's the report.
I have it, I'm sure, in the exhibit that was attached to the motion that was filed by the prosecution.
Yeah.
Your Honor, what's the page? Describe the report now. What is the typewritten page number at the bottom of the report? Does it have one?
268.
268?
Yeah.
Thank you.
Your Honor, am I to infer from that they are trying to offer the shower statement now against Eric Menendez? Perhaps Mr. Kuriama will argue they're taking the shower together.
Well, number
That's
one,
quite
this
plausible.
is a statement attributed to the defendant Lyle Menendez, so it's only being offered as to him, I suppose. Is that right?
Yes, Your Honor.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
Judges, the court can see also can read on that statement the genesis for the statement was not really Miss Eisenberg, but it was the investigator from Live Entertainment who calls Eisenberg up and suggests to her that he had heard certain information. So we have the collateral issue of the reliability of what she overheard. And I also, in that regard, on the unreliability aspect, of this note for the court that in her notes, or the prosecution's notes of this statement, she says that it was a throwaway conversation, thought she'd misunderstood. So the prosecution is really seeking to get a lot of speculative mileage, I think, out of this statement, which on its face refers to being in the shower at the time of the murder. And if it's admitted, there are impeachment issues which would need to get explored, both in terms of the people who interviewed her prior to and after taking the statement, as well as the live entertainment investigator.
Well, first of all, it would help the court in evaluating this, whether or not this specific conversation was in fact ruled upon by the court. As I said, my recollection, it was not. Your recollection was it was, but if it wasn't, your position is that generically any such evidence should have been offered. I don't agree with that. So first, I would like to see if the defense has relied upon a ruling of the court that this was going to be offered by the prosecution. And if not, then the court's view is that this is proper impeachment of the defendant, Lyle Menendez. And, well, just do it. Don't tell me how you find it. Just find it if there is something there. I really don't want to consume any more time about how you find it. What else is there in relationship to Ms. Eisenberg's testimony?
I'll just, on page 20, there's a statement by Lyle Menendez, an opinion, a conclusion about, are you offering this against Eric Menendez?
Let me get there. No, it's not offered against Eric Menendez.
Our objections would be the same as the two prior statements or the first statement we discussed, Your Honor.
It's even worse. What is it?
And
rather than see improper rebuttal.
All right. Again, was this known by the prosecution beforehand?
No, Your Honor.
It's in the notes of November the 21st. What is it that is being offered to prove that?
Well,
the statement is in relationship to a conversation about Eric Menendez doing or speaking at a service or performing a eulogy.
Yes.
And the quote of Lyle Menendez was, "Don't worry, my brother's a good actor."
Correct.
What is it being offered for?
It's being offered because of the defense posture that the grief and emotion which was exhibited to Sergeant Edmonds on the night of the morning of the 21st was genuine. And I believe that Lyle Menendez himself testified that he was worried about whether or not his brother was going to be able to make it through the story with Sergeant Edmonds, and that Sergeant, and in fact, he sent his brother in first, and if his brother didn't make it through, they were supposed to signal each other. And I think this is corroboration that he, in fact, believes that his brother is a good actor and was able to make it through that particular time. And I think it also goes to dispute the notion that this is genuine grief felt by these defendants, but in fact is something that is an act.
Yes.
It's an ambiguous statement. It could just as easily be saying, my brother feels genuine grief and is good at hiding his genuine grief.
Yeah, I don't see how this really proves or disproves anything. It really is ambiguous what it means. So the objection is sustained under Section 352 of the Evidence Code. I don't really see it proves anything.
Now, Your Honor, on page 21, there's an addendum at the top. It says, and I haven't highlighted it, but I would like to use it. It says she picked Eric up at high school at Calabasas when Kitty back east, before she, being Kitty, moved here. That's supposed to be here. Ms. Eisenberg indicated that Jose and Eric Menendez came to California and set up set up house prior to Mrs. Menendez moving out permanently, but that Mrs. Menendez would commute back and forth, and that during this time, Marzie Eisenberg often picked Eric Menendez up from high school because his mother was unavailable because she was still commuting between the two homes. And it says here, Jose did sometimes too, meaning he also picked up Eric from high school. The relevancy of this is I believe that Eric Menendez indicated that in regards to the child molesting, that when he first got to California, that it had abated. And it would be the people's position that if in fact Mr. Menendez and Eric were living alone in California for a period of time, that it would be inconsistent with the theory that he is a child molester, that he'd be alone with his son and not take advantage of the fact that he was alone. So that's the offer, and we would like to now use this. And in front of both juries, simply because Eric Menendez testified to the child molesting in front of both juries.
Well, Your Honor, the problem with this is that Ms. Eisenberg is completely wrong. We called 20 witnesses to prove this, but we have the family moved, the moving van came, Mrs. Menendez came, she met Karen Farrell, who's their other witness. She called her, said they were moving out. They talked about getting Eric into Calabasas High School.
Well, let me stop for a second. I just don't see that this is proper rebuttal. It doesn't rebut anything. The argument of the people is one that doesn't really hold water. I don't see how it proves or disproves anything. It's not really proper rebuttal. It doesn't refute anything. So the offer is, the objection is sustained. All right, what is, any objections to anything else on page 21?
Yes. There's an objection about the statement by Kitty Menendez that Kitty Menendez, was up all night with Lyle till 6 or in the morning. She was exhausted. This sounds like pure hearsay, statement of past acts or belief.
Your Honor, this information came in through Dr. Cox, I believe, or one of the experts testified, and you know what? It may have been Dr. Conti, who slipped in that there was evidence during the week that Kitty had been up all night on the phone. I specifically recall that because I was startled that he had mentioned that. But more importantly, this is a statement of Mrs. Menendez's state of mind at a time period which is crucial in this case.
When is the time? I don't understand.
Well, I'm sorry, Your Honor. I think because and the reason I made this note is because it's in the Kroll report, which I don't think the court has.
I don't know, what is a Kroll report?
Okay, Kroll was an investigative firm hired by Life to investigate the homicides, and what it refers to is the Wednesday or Thursday of that week. That would be the 16th or 17th of August, and that is when that is the night. It was either the night of the 16th or the night of the 17th that Ms. Eisenberg was referring to. It's also in the one of the police reports that the defense has, I think. Let me see.
Well, what is this? A conversation by Eisenberg
with Mrs. Menendez.
Mrs. Menendez on Tuesday.
Okay, Your Honor, from the police report, which
2 different dates. It depends. The police report says one date. The Kroll report says
okay. Yes, the police report indicates the police report from the 22nd of August. Okay, that was when they talked to her. 22nd of August of '89. Second page. Marzi recalled that on August the 16th or 17th, while Jose was on a business trip, she received a phone call from Kitty, who was complaining about being kept up all night the night before talking to Lyle on the phone. It was her impression that there was some type of family problem. So this, I know the court doesn't have that report, but the defense does, and this is a reference to that particular conversation.
And what date was this supposedly?
August 16th or 17th, which would have been the Wednesday or Thursday of that week.
And what is it that you're offering it to prove?
We're offering it to prove that, in fact, she did have a problem with her sons, but it is not any of the problems which have been described by the defendants in their testimony. I believe that the testimony is that on August the 15th, the hairpiece was ripped from Lyle's head, that he then went and spent, I think that was the first night he spent with his brother in the guest house. And I believe I even asked him if he talked to his mother on the phone. I can't recall if I did, but this contradicts that and indicates that there was a family problem during that week, but that the family problem was something that was not is not anything that's been described by either of the defendants during the week between the time period of August 15th through the 20th.
All right, and there has been mumbled the defense objection that it's hearsay.
Yes, Your Honor. And once again, the people are offering statements of Mrs. Menendez, which are to show her then existing state of mind. And
what is the state of mind?
Her state of mind is that she had just been up all night. It's also offered under 1240 as an excited utterance. And I think that considering the amount of hearsay that has been admitted in order to show states of minds of the victims at various times, that this is well within the bounds of those kinds of statements and should be admitted to show that she, in fact, was of the state of mind that she was exhausted because she had been up all night with Lyle.
The statement that she had been up all night is not state of mind. It's a fact that is being offered to prove that she was up all night, and that can't be state of mind inception.
It
Beyond
does
that-
sound like it is hearsay and offered to prove that fact that she was up all night. It does sound like hearsay to me.
Well, Your Honor, if I'm able to find the reference in Dr. Conti's testimony, which I believe,
I think I can clarify that. I believe what he was talking about was the calls between Mrs. Menendez and Mr. Menendez at the grandmother's house in New York. I think that's the reference to, that's
Well-
the only reference to phone calls that I can remember. So I think that's the reference.
Well, obviously, if there's some other reference that you feel that ties into this in some way, I'll certainly consider it. But from what you're presenting to the court, it sounds like classic hearsay. It would not be admissible. What else is there objections to on page 21, if anything?
Well, the next paragraph, the fact that although she doesn't remember the last time that she saw Mr. Menendez, which is what that refers to, Your Honor, nothing was out of the ordinary. I mean, she either remembers something or she doesn't remember something. I just think that's unreliable.
Well, when did she last see him? Is there some information?
she saw him Friday, the 18th of August, after he got back from his business trip. And if you go down to the second from the bottom where it says Jose transparent, obvious to Marzi if he was upset, that's in reference to this particular thing. In other words, he was not someone who was consistently in a good mood at work. She originally told the parole investigators that he was in a very good mood that day. I questioned her about it. She said she has no present recollection of that fact. She does recall that there was nothing out of the ordinary about him and that he was sometimes in a bad mood and that she would have noticed that because he was not one who hid that, and that she recalls that there was nothing very good nor very bad about his demeanor that day.
Well, she certainly can be asked questions regarding observations she made of his demeanor on that particular day. And if she can describe it, she can. If she cannot, then she cannot.
She can't say she would have if she could have, because
Well, we'll just have to wait. That's something that can be asked and question and answer and objection if there is one.
the next thing I object to, Your Honor, is her conclusionary language that at the end, Eric was becoming the star, the glory being transferred to Eric. Clearly, she doesn't have personal knowledge. This is rumor, hearsay.
As well as the
Conclusion.
On behalf of Lyle.
Yeah, Lyle always something.
What is the
wrong.
people's offer there?
Your Honor, as far as the Lyle always being something wrong, we would withdraw that. As far as the, I'd have to ask you further questions about this. It's my impression that this is because of the way the parents spoke of Eric.
All right.
Still a
And
conclusion.
if in
right?
fact the parents spoke of Eric in terms that were favorable, I would offer those to contradict the notion of the heir and the spare, which has been promulgated by the defense, that Eric was in fact just this throwaway child.
All right, you'll have to discuss it with a witness, and if there is some specific conversations, you can disclose that to the defense.
I'll have Detective Zoller contact her then.
Yeah.
Anything else? In regards to her testimony, any other
I think
objections?
we've gone through everything.
22, I think we've covered that.
We've covered everything, Judge.
All right, then that completes her testimony. There, other than the research relating to the defense objection to a particular offer of proof by the prosecution, everything has been ruled upon, other than any specific questions and answers of the witness.
Just one question, Your Honor. I don't think it was specified, but I think the letter issue, Mrs. Bozanich, is only being offered as to Lyle.
I'm sorry, I was talking to Ms. Lansing.
I wanted to just inquire
What?
the issue about the letter. The court's, it's still up in the air about
Which letter?
the letter that Ms. Eisenberg claims she saw that Lyle might have read.
Right. Well, we need more information now. We don't really know specifically what she's going to say.
I just
Yeah,
wonder who
and-
it's offered against.
Well, it's only against Lyle Menendez.
That's all I wanted to know.
That's what the people's position was, wasn't it?
It wasn't clear.
I think so, Your Honor.
that it was his file, and he supposedly referred to it in his remarks.
Well, I didn't write down, the reason I think it's relevant as to both defendants is because I think that there's been a joint defense that the father, to portray the father in very unflattering terms vis-a-vis his children. And that was done through the testimony of Eric and Lyle Menendez in front of both juries. And I think that this would dispute that particular notion. And even though it only goes to Lyle Menendez is one, I mean, he did testify in front of both juries. So I don't think this should be limited, assuming we can lay the foundation. I don't think it should be limited to just one defendant.
What's wrong with this simplifying what the defense? This isn't that simple a defense. Eric Menendez testified he always thought his father loved Lyle. This doesn't contradict. I mean, we were talking about two different people having different relationships. Even on the tape of 1211, Lyle Menendez is saying, or Eric Menendez is saying, they're two we related very differently.
All right, what I would like to do is know, as I said, specifically what it is that occurred, whether the defendant, according to the witness, quoted from the letter or just said things that rang a bell in her mind, of things that she read in a letter, number one. Number two, as to any specifics, if she has any recollection of specifics of what was said, so that we can at least have some basis for discussing it further. Right. Anything else in relationship to testimony of witnesses?
Still on hold for the show.
The agreement not to object to the calling of defense experts on the grounds of improper rebuttal.
Yes.
That's in volume 124 at pages 20,891 to 3.
And what does it say?
It says, it refers to defense experts and in the plural, and also refers later on to Doctors Maloney and Vickery. There's 3 different pages that it's discussed, but there's clearly contemplated that there would be 2 experts called.
All right, my recollection, it was specifically related to Vickery in relationship to whether the people were going to call a witness. That's why the defense was up in the air as to whether they wanted to call Vickery during their case in chief and wait until after the people had put on their rebuttal before they decided to. And my recollection was Vickery, but I'll review it. You have the actual transcript there, or just notes, or what?
I have it on my computer and pulled it up. I have it right here for the court.
No, I'll certainly look
Can you
at
put
it.
it on the bench, the judge can see?
And as far as the court's direction to counsel, regardless of that, I still want an offer of proof as to what they would say as to why it's not cumulative.
We should plan to have.
Anything else relating to testimony of witnesses? And again, just because you didn't call somebody in your case in chief, you should still use some good judgment as to whether or not this is really something that should be introduced at this stage of the trial. Don't just call a witness because you have thought more about it and would like to put on some more evidence. It's not really the basis for making these decisions. All right.
You're referring to the expert study. That's not the issue. I always intended to call Dr. Baker. I'm still not sure about Dr. Maloney.
Well,
so I mean,
why don't you make up your mind on him so then we don't have to worry about him if you're not going to call him.
I'm
So,
going to meet with him on Sunday. But the point is, I always knew I wanted to call Dr. Baker because there were things he could testify to that the others couldn't.
all right. Well, you'll have to isolate what those are because, again, we've heard extensive testimony on behalf of each defendant or by experts. And if there's any duplication there, especially in light of the fact the prosecution hasn't offered any other contrary evidence, I want to hear what it is before we have that testimony offered to the juries.
It's only one jury, it's not going to both juries.
Your Honor,
Regardless.
it's the defense position that people are not entitled to rebuttal witness statements because it's not contemplated by 115. And I'd just like to point out that it appears to me that the idea is always that the people would have to provide sir rebuttal after their rebuttal. So it seems to me like there's always a continuation that as soon as the people find out they have evidence to contradict that which the defense presents in their rebuttal, then the people would have the further obligation, if they're going to put on more witnesses, to provide that. So it's a continuing obligation. And so I think the argument that we're not entitled to know who these people are or to know anything about what they're going to say fails, because just because we may choose not to call any further witnesses after they put on the rebuttal doesn't mean that we couldn't. And therefore, we always have this continuing obligation. And I don't know what case or they're citing that indicates that we are not entitled to the rebuttal.
The problem is that they're not entitled to it now because they haven't finished their rebuttal, and
Yeah.
we don't want them to tip their witnesses.
That's really what we're talking about, that why should they be giving you their witnesses before you finish
yours.
your case, so that then you'll be putting on witnesses to refute their rebuttal before they get a chance to put it on.
Does that mean we didn't have to give them our rebuttal witnesses when we
No,
did?
once you've made a decision that
exactly
you're going to call a witness, then you would, but at some point we have to,
But
call
we,
a halt to that.
I know, but I mean, they were able to anticipate our rebuttal witnesses because we gave them their names and the statements all throughout the defense case. And in many cases, they were able.
Well, you know most of these witnesses that they're calling. So
But is Azaga required that, Your Honor, in its footnote, or it would be constitutionally not fully reciprocal?
Okay,
That's really why.
really, as I understand it, you've been provided basically with who these witnesses are that they're calling.
I have no idea who these character witnesses are because they're called character witnesses for Brian Anderson. I mean, who's that?
When Brian is finished testifying, then we will tell you who it is.
All right, well, then who's the character witness for Jamie Plazarczyk? Because she is gone.
That's a witness we haven't determined for sure to call. The witness is
Okay.
deciding whether or not he will or she will testify.
All right, then you make that decision by Monday and turn it over to the prosecution
Oh,
on
it will be
Monday.
made. It will be made by
Make
Monday.
it by Monday so that we don't have any delays and the prosecution has a chance to research the matter.
It could also be volume 49.
All right, let's turn to the exhibits then. There was a new supplemental list provided to the court today.
This is my was from my notes. I
I corrected it for accuracy. I've been trying to take good notes.
What is, as far as what's been given to me, it's a list of November the 14th with the attachment prepared for today. Those matters highlighted, as I said, I would like you to indicate those things that are really subject to further litigation rather than just preserving the record.
Your Honor, we talked about this at lunch. We really think the most expeditious way to do this is to just do it. Start at one and we will just tell you. This is just an objection being made because we previously.
I don't want you to say that. I just want you to identify those things that are for the record. I don't want you to tell me all those things that.
That's what I mean.
No, I want you to tell me things that are not just for the record. Otherwise, we can be here all, forever. So I do have a list and it's highlighted, and I assume it's been highlighted by the parties, and it's something that you all have, and you can.
No, not the November 14th list hasn't been highlighted.
No, we don't have a highlighted November 14th.
Well,
Well, the earlier list should be the same, other than the additions after November the 14th. So if you have some earlier highlighted list, do you have any list?
The only thing that's highlighted are the objections in yellow. So all you have to do is go down the objection line and see where it says objection.
Okay.
I see, okay.
And you can highlight
That's all
yourself.
the objections, Judge, that's highlighted to you. That doesn't
Right.
help you.
Well, it does, because we'll just go through, I'm going to number the pages as we go through them, since they're not numbered. And I want you to indicate to me those things that are subject to argument rather than just preserving the record. So on page 1, what is there that you want to preserve the record, or that you want to argue? Not just preserve the record.
I think the first one is 20. Our position is that diagram is inaccurate. And I think it was virtually conceded that it was.
Your Honor, the inaccuracy which has been corrected in front of the juries is that the coffee table in the diagram is at a more acute angle towards the sofa than actually at the scene. And I think that's been made clear, and I could make it clear again when Detective Zeller testifies. But in terms of everything else, it is accurate, and I think that it is the only diagram we have of the particular crime scene.
I think it also was not to scale. I think it's more confusing than illustrative at this point.
No,
because it isn't fixed.
I think Detective Zeller can testify it is to scale. We have the measurements, and
Why don't the people just do a new diagram and substitute?
All right, if this has been referred to during the testimony, and if there's a foundation established that it is to scale, and it's been clarified already regarding the positioning of a certain object, the objection is overruled. Anything else on the first page?
No.
All right, then everything on the first page will be received.
No.
With 20 will be received unless there's a further objection by the defense based upon the further testimony of Detective Zoller. What?
12 is withdrawn, Your Honor.
Yeah, those, with those things being offered are received, except for those things that have been withdrawn. It's listed on the list here, so we don't have to go through it.
Okay, so we're going to make, is the court going to mark a copy of the list as an exhibit so
Does
that,
the clerk have a copy of this list? Okay, why don't we, here's November the 14th.
And then I have the new.
I have another one.
Okay, I've given her the November the 14th list.
And then I have the updates.
Okay. Everything on that sheet that is being offered is received. Those things that are being withdrawn are not being received. Those things that are not being offered are not being received. So it's
Very much. It might just be easier, Your Honor, and just to indicate the numbers of the things that are withdrawn on each page. There aren't that many, to make it easier for the clerk ultimately.
all right. If you want to do that real quickly, as we find them, Exhibit 12 was withdrawn. Everything else is being received. All right. And on second page, we'll number that page 2.
Your Honor, I believe we have objections to litigate to items 44 through 48. And then on, in item 53. Actually, and it's to Lyle Menendez, 54 and 55.
Those are real objections or for the record? No,
Those are incorporating prior arguments.
Okay, these are not anything new that you wanted to add. These are just objections that have previously been made. It's all right.
So 44 through 48 are real objections. 53 is a real objection. The others are to preserve the record.
Okay, and 44 through 48. Did you want to argue that?
Well, I think 47 and 48 were offered by the defense.
Yet you're objecting. We're assuming you mean it.
Right.
So let's go 44 through 46 then.
Okay, I think the court can recall with these things where this was a general educational diagram. It did not illustrate anything relevant or specific to the case or to the type of gun here or to the type of pellets. And we think it's would be confusing and deceptive to the jury to see these patterns and make anything of them because they have nothing to do with the actual shooting in this case. And the same is true of the diagram of shotgun shell. It's not the type of shotgun shell that was used here. It's different and it looks different. The manual of Mossberg shotguns is full of hearsay.
Well, the manual itself is not going to be received. The objection to 44 and 45 is overruled. On 46, if the photograph, if you want to identify a photograph of the weapon that is most similar to the weapon in question, you can do that.
For that particular model.
Yeah.
Okay.
But the whole.
I don't think the whole manual is in here, Honor. I think only Xerox certain page.
No, it's there.
Well, I know you had the manual here and you also had Xerox of it. So you don't have to go through it now, but the objection is sustained at 46 with the understanding that you can modify it if it can be isolated to the gun in question.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
And then the people object to 47 and 48. Let's say 47 first.
Yeah, 47 was when Ms. Abramson took apart the shotgun shell with
the diagram.
And I don't know what the relevancy of that is.
Well, that's an accurate example of what one of the shotgun shells in this case looked like as compared to the diagram above, which is not accurate to what the shotgun shells in the case look like. The reason I did that was because I thought the 45 was so misleading. The jury should see what an actual shell like the one that could have been fired here looked like.
Then that's fine. I would withdraw the
All right,
objection.
as far as 47, my recollection is that there possibly is some powder as well that will have to be
I'll make sure
separated.
it's
And
separated.
only the paper casing and the plastic or whatever else was inside the cartridge or shell can be used as an exhibit. So it'll be received with a modification. And council will have to deal with that. As far as 48, it was offered as to Eric Menendez only.
Yes, we introduced it. There was testimony by Craig.
I recall what it is. What is it?
That is hearsay.
All right, it wasn't offered for the truth. It was offered to show Signorelli's conduct, use of some nomenclature, as I recall. It was an issue in his testimony in relationship to the defendant. Is that right?
Yes, Your Honor.
Can we wait till Mr. Kuriyama comes back, please? He's looking for the transcripts so that he can make his objection.
All right, we'll hold off since that relates to Mr. Kuriyama's case.
Your Honor, can we have a biological break?
Well, let's at least finish this page here. 53,
All right, the only-
54, and 55 are
No,
objections.
53 is the only one, and the only objection there is that since they already have Exhibit 52, which the jury can look at, the blow-up was purely for illustrative purposes during trial. There's no reason why they should have the blow-up in the jury room. They already have the documents.
All right, that is a issue that has been testified to by all parties, both defense and prosecution witnesses. It's the shotgun purchase records, and to assist the jury in looking at them, since it's an issue directly related to this, what's been produced by both sides. The objection is overruled. It's not a diagram or anything. It's just a photo enlargement of the exhibit.
Fine, then we'll object to 52. They don't need it both ways, I suppose. How many times?
Well, I don't see that the jury's going to be using them both. They'll use one or the other, and just for their convenience and deliberations, it seems to me proper to use them both. It'll be received. All right, what is 54 and 55? What is those, just to preserve the record? Or?
Yes.
Yes.
Okay, and that's only as to Lyle Menendez, so they'll be received.
There's nothing withdrawn on this page, Your Honor.
Okay.
We're at the end of the page.
And then, again, on page 3,
61, Your Honor.
that's only as to Lyle Menendez.
No, I believe that came in as to both Eric and Lyle Menendez. 61 was.
Okay, during the Lyle Menendez case, it was marked for his purpose only, and then during the rebuttal, strike that, during the defense case, it was brought out by the defense during the cross-examination of Goudreau during the Peoples case, and then during the defense case, you called Goudreau back, and it was shown to him at that point. Is that right?
No, Your Honor. Mrs. Bozanich asked Lyle Menendez about it on her cross-examination of him
Okay.
and referred to it specifically.
Okay, and then you showed it to him at that point. That's right.
Yes.
Okay. What is the people's position regarding that?
The people's position is that this is this letter written to Mr. Goudreau should be excluded under 352 because it's an attempt by Mr. Menendez to portray himself in a good light right before Mr. Goudreau testified, and also that the contents of the letter are hearsay. So for both of those reasons, it should not be admitted.
Your Honor, it was referred to both times in this courtroom by the prosecution, not by the defense.
Oh, I don't believe that's correct. I think it was brought up by Ms. Lansing with Mr. Goudreau on his first appearance on the witness stand.
That is not correct. Ms. Bozanich asked him when he had last heard or if he'd received a letter, had some contact with him. He referred then to having received a letter from Lyle Menendez. And I think at that time, there was a stipulation entered. I can't remember for sure, there's discussion about a stipulation because my concern was whether this looked like this was some sort of a threatening letter. We then marked it And then Mrs. Bazanich asked Fla Menendez on her cross-examination, isn't it true you wrote a letter to Donovan Goodrow to try and portray yourself as a good guy? And La Menendez's answer was, I am a good guy. So both references to this letter came from the prosecution.
But that doesn't make it the contents admissible.
Well, I think that now the jury may speculate in terms of whether there was any sort of negative communication there. And I think since they've brought it up twice, the jury has a right to see what it's all about.
Wasn't the letter read, portions of it read by the witness?
No.
I don't believe so.
No, Your
Seems to me it was. It somehow, the contents came before the jury. It wasn't just the exhibit itself, but somehow it was referred to in the testimony.
No, Your Honor, I think what happened is that in order to avoid the idea that it was a threatening letter, that it was characterized as a favorable letter.
Yeah, that was during an earlier stage in the proceedings, but then during the, my recollection was it was during the examination of Mr. Goodrow when he was called back, that somehow the defense read portions of it to Mr. Goodrow.
Okay, well, can we?
You can research the record
Yeah.
on that one and make a determination as to if it's portions have been read, then those portions are already before the jury and it doesn't have to go to the jury. Let's first find out what happened. You can research that matter. What else on page 3?
There's
66L. 65 and 66.
We have nothing to add to
Okay, those
previously made arguments with regard to any of the exhibits. The people have a few
Your Honor,
items.
I know does the court have some red ink on this page?
Yes.
All right. The Eric Menendez jury only for 68 and 69 is incorrect. Has that been corrected?
You've corrected that, made it Lyle Menendez.
It's the Lyle Menendez jury only.
Correct. Okay. Do you want me to argue those at this point? Those particular items were things that were shown to Mr. Wicken during his testimony. And
There's no foundation as to where they came from. It's
Exactly.
my recollection that they were just things that were somehow prepared and we don't know what the source was.
That's correct. And then as to 70, which is in front of both juries, Mr. Wicken was cross-examined by me at page 89, 35, and 36, it looks like, where he said that this could be recreated at any time, that the timestamps in that particular brand of computer are unreliable, and therefore there's no way of knowing that that particular document was created in 1993 or in 1989.
Okay, there's no foundation as to either 68, 69, or 70.
But the problem is that he also testified that 70 looked like what he saw on the screen. And so in that sense, he authenticated the information and the setup of 70.
Well, he didn't have a clear recollection of every the detail of it. It looked similar, but there's no foundation as to where these things came from. I noted it at the time when they were marked. My notes, when I put them on my list, there's no foundation. Nothing has occurred since then, so.
Oh, we have the.
Objection is sustained to those. They will not be received. 68, 69, 70.
Okay, 71, we did have an objection to.
Huh?
And that's the blow up. It's our position.
I don't see it. It's 71?
No.
Yes.
Okay.
It's our position that if there are records of these items, it unduly emphasizes them to have the enlarged version.
Yeah, in regards to this exhibit, I agree. It's not, it's just some corroborative evidence or circumstantial evidence. It's not the type of evidence that I referred to as relating to this purchase of the shotguns.
No, Your Honor, it has to do with the purchase of the.
I understand that.
Oh, okay, but
Yeah.
can I substitute the smaller copy on just an 8.5
Well,
by
don't you
11?
have a smaller one?
But it's not in evidence, so I'm asking permission to
Oh, I
substitute.
thought there was.
No.
This was money. It had to be done big.
Sure, you can substitute a smaller one, but
Yeah, all it would be is just the credit, there's 3 credit card receipts and just on one page and they're normal size.
okay, why don't you do that?
I will.
Also, so it doesn't burden the clerk in having to distribute these to the jurors. The blow-ups are nice as exhibits for argument and things of that nature, which you can use it for, but to give them to the jurors really doesn't prove anything, and it really is a burden on the clerk. So 71 will not be received, but may be substituted. All right, anything else on this page? Other than the pro forma objections?
No.
Your Honor, does the court copy indicate that the prosecution is withdrawing number 83?
I was going to read the list.
Yes.
Exhibits withdrawn on this page, Your Honor, are 62, 65, 67, 72, 73, 74, 82, and 83.
Yes.
Correct.
Okay, and then page 4. 84 was withdrawn.
Yes.
Any objections to any of these other? People have objections to some, defense have objections to some, other than the pro forma objections or the, I don't want to mischaracterize them, the objections that were previously made. Any further objections to any of these exhibits?
Yes, Your
Your
Honor.
Honor,
I'm sorry, go ahead.
it's to number 96. That was not introduced in the prosecution's case in chief, and we would be objecting to it.
96 was marked for identification only.
Okay.
Your Honor,
The time it was referred to.
Your Honor, I have to check Lyle Menendez's cross-examination. I was planning on reading this testimony this weekend. I'd like an opportunity to do that, to see if I used it during then. I think I may have. Otherwise, it was not used during the coroner's testimony, certainly. And then I'd like to point out at 94, which is the defense objects, that photograph was used by the defense.
First?
Yes.
Only after, I think.
Well, I don't know if,
it was used, and it was used.
yeah, it was used at page 9222.
Negate any objection if it was used.
Mhm.
So it's hard to object to an exhibit that you've used in your examination of a witness. Well, I guess you do
Oh, no, it isn't. It's just hard to do it with a straight face.
successfully.
Yes.
Any other arguments to relating to any of these other exhibits?
Yeah, I'd like to take another look at 98 and 99, Your Honor, to see if they can be properly redacted, because I think it's important for the jury to understand
Sure.
just how
Sure,
busy.
those are Oziel's appointment
Right,
books.
exactly.
Yeah, you certainly can do that. Why don't you go through here and indicate those things that have been withdrawn?
Okay, on this page, withdrawn was, I can say 84, 98, well, that's what I want to discuss, 98 and 99, 100.
That's it.
That's it. Now, there are real objections. I hate to use that word, but I mean, litigatable. I guess the prosecutions are seriously objecting to.
103 through 106.
Okay.
What about 101?
Yes.
Okay, so they're 101 through 106.
Yes, that's correct.
Okay. And 108 through 110. Are you still objecting to his CV?
Okay.
And 112, you're still objecting to that? These are all things that were.
I'm trying to remember 112 letter for Jubilance. Oh, that was the letter that was written.
That's his
That
fake
was
letter, the diagnostic letter.
Right.
She testified about that.
So did he?
Right.
She did, so,
Yes, she did.
too.
okay.
All right. As to 101, well, 101 is different from the others. People's objection is that it's irrelevant that she signed this agreement.
Well, what was relevant about the reason it was brought in is because it was fraud by Dr. Oziel. She hadn't met him as of June 1st, and she's testified to that, and he was
Okay,
cross-examined.
101 will be received since it's been referred to during the testimony and relates to also potentially the testimony of Oziel as to documents that he felt could be uncovered by the defense with
Right.
her name on it.
That was during the 15.5.
No, I think it was
Mainly.
during his testimony as well.
No, he said that too. Yeah.
All right, 102.
102 through 106 are a series of correspondence with Dr. Oziel after the case was filed, in which they were trying to get information from him, and it's his responses to them. And it would be the people's objection that the communications between Dr. Oziel and counsel are irrelevant and contain hearsay material. And I'm not entirely sure if this was in a 402 or if it was in front of the jury.
This was in front of the jury because Dr. Oziel was coming up with new stuff and claimed that nobody had asked him about things before. And so we presented him with these very detailed requests for information that had been given to him, and his response to that, which is that he had no additional information, in order to impeach his credibility on all this new stuff he was now testifying to.
I think he also testified that his responses were on advice of counsel.
No, I think he said he didn't have, he said he didn't have anything else, that's all.
Does the court recall these particular exhibits?
Yes, I
Whether-
do. I
okay.
have my notes here, and I've already written a note at the time that as far as 106 is concerned, I didn't regard it as relevant evidence. And if I regarded it then as such, I regard it now as such, so 106 is not going to be received. As far as 102, 3, 4, and 5, that just relates to the ongoing efforts by the defense to obtain information from Dr. Oziel. It was all part of his testimony in relationship to what he could or could not disclose, and the prosecution's objection is overruled and they'll be received. The only caveat would be if there was any doubt in anyone's mind that this was introduced before the jury, you can review the.
Yeah, it doesn't make any sense.
101 through 105 are.
Your Honor, I need to take a look at 106 again. Does it make any sense to allow that in and then keep out 106, which is his basic stonewall in response?
Well, if you take that position, then we can.
Yes, we could,
sustain
but
the
I'd
objection
rather
to
we went the
101
other
through
way.
105.
Well, can we look at 106 and just make a
Certainly.
note to revisit
Yeah,
this?
but at the time I viewed it, I had formed that opinion. I don't think anything is going to change at this point, quite frankly. Anything else on this page?
Yes, 108.
Well, these are the people, why don't we have the people indicate what their serious objections, even though we suspect it is?
Well, the accusation by the Board of Psychology contains a number of accusations, and the people would object to those as being hearsay, and they're
Right.
certainly inflammatory.
All right, that is sustained. It's just an accusation. It's been referred to and won't be received.
I believe Exhibit 109 has been sealed.
Yeah, it's not received.
The reason we object to this Dr. Oziel's CV at 110 is because he was not offered as an expert witness.
Oh, but it definitely was.
Well, he was
tested.
examined on it, and
Yeah.
it'll be received.
But there's been no testimony about it.
All right, anything else on page, it's 112 was the,
I think that was the letter that was written for her to keep her out of court.
okay, it'll be received.
Okay.
All right, and 84 was withdrawn, and you indicated that
And
one
one,
98, 99, 100 has been withdrawn.
right, 98, 99 were on review, 100 was withdrawn. We'd like to be able to make perhaps a substitute for 98 and 99.
All right, page 5. Right, there are some question marks near the top of.
Yes, Your Honor. I think that the problem with the boarding pass was the lack of authenticity, and I believe that objections withdrawn to 116.
Okay, 116 will be received, 115.
Your Honor, those were documents that were prepared by people with Dr. Oziel's consent regarding a press conference he had. And to that extent, they would be hearsay and also irrelevant. I think he testified that he had had a press conference. I don't think the documents are competent evidence of that.
You said they were or were not prepared with his consent.
They were.
Okay, they'll be received. All right. Then we have a series of audio tapes.
Yeah.
There's a whole series of audio tapes, not just here, but elsewhere. And I think we have to deal with them all together. And also, Mr. Burt, regardless of whether these are received, specifically, you indicated that you would supply the court with redacted copies of the audio tapes and also transcripts of anything that was played during Ms. Smith's examination.
I will, Your Honor, and I'm in the process of doing that. I wanted to review the videotape of Ms. Smith's testimony to make sure I was accurate in terms of my notes on what I played and didn't play. And I also was waiting to see if Dr. Ozio was going to testify because I thought there would be more of the tapes revealed. But since he's not going to be out, I now can complete that project and have those for the court. In other words, redacted versions of all the tapes as well as transcripts to go along with those.
Okay.
Each individual tape.
All right, I'm going to hold off discussion of these tapes and other related documents relating to Ozio as far as Ozio and Smith until we get them all together at one time. Otherwise,
Make you
we'll be
crazy.
bouncing around here.
Your Honor,
114 was withdrawn, is that right? It's not being offered by anybody?
114,
Yeah.
I have it as no objection.
It's not withdrawn. It's just,
Oh, okay, it's being received. Both sides are offering it. Or there's no
The
objection?
defense is offering and we're not objecting. It's okay. 120, there's going to be a change. I would like to offer it as to the Lauman industry as well. Those are the love letters.
Okay, as I said, let's try to deal with
Okay.
everything relating to Ozio and Smith at one time. So
Oh, okay.
even whatever else it is. Other things relating to Ozio we can deal with here. Well, let's hold off. I think maybe I'll just hold off on everything else relating to Ozio until we get to put it all in one discussion here. Otherwise, we'll be bouncing back and forth. So let's go down page 5 to, without ruling on anything else on page 5, to the next thing that doesn't relate to Ozio, which is 128, I believe.
Yes.
Okay.
I believe 128 through 133 were submitted on prior argument.
Okay, those will be received. And 134 is withdrawn.
Yes. 135 is the 9/11 calls, the transcript.
Okay. Any objection to 130? Well, there is objection. Anything further on 135?
wait a minute. Can I just have a moment?
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
Each time we ever played a tape, that the tape was the evidence, not the transcript. And here they're getting copies of the transcripts as well.
Yes, well, the transcripts are, again, and if you want to prepare a special instruction along those lines, are only given to the jury to assist them in listening to the tape recordings.
Well, if they're in the jury room and they want to play the tape recordings, are they each going to be given copies of the transcripts, or is it just the one exhibit copy that's going to be?
I would make copies available to everybody, otherwise it would make it more difficult unless you have some strong objections to it. That's normally how we do it.
Okay.
With the understanding that I would instruct them, you can prepare one relating to dealing with those, or you just remind me and I'll do it orally without a written instruction. But with all the material given to the jurors, if they have anything to help them along the way, it certainly is appropriate to do so. All right, so 134 is withdrawn. 135 is an objection that's received. 136 is not in evidence, it's for ID only.
What did you do with, excuse me, Your Honor, what did you do with 128
Those are all received. Those were objections that have already
Okay,
been
no.
made, ruled upon.
Okay.
I'm deferring ruling on 117 through 127 at this point.
I understand.
And 137 through the balance of the page, other than the objections already made. Anything further? All right, they'll be received. 139 is withdrawn. All right, what else? The next page here, which is page 6.
I put in 2 copies of Mr. Menendez's will and none of Mrs. Menendez, and I wanted to substitute. So is there an objection from the defense to me doing that?
To do what? Substitution of?
To take out one of Jose's and put in one for Mrs. Menendez?
Or objection to any wills going in.
Yeah, we think they're
But
hearsay. There's no,
If they're coming in, I don't object to the substitution,
Okay.
but we would object to them coming in.
All right, did you want to argue it further, or is it submitted?
no, I think they're hearsay. I don't think they prove anything in particular above and beyond what was already testified to by witnesses that they don't, I mean, all they do is leave things to each other and then to the defendants, and there's never been any proof that they saw these wills before their parents died, and I think the jury will, if it's in front of them, perhaps make that assumption, and that's why they shouldn't have them.
Well, there was a substantial amount of evidence relating to the wills, including that of Marta Cano, as offered by the defense.
But we didn't offer the wills. I mean, all she talked about was, there wasn't really substantial evidence about the will from her. It just had to do with having a discussion with the defendants about whether they were inheriting or not the content
Well,
of the
as I
will.
recall, it was discussed during her testimony and also that of Mr. Baralt, as I recall.
Yes, but the point is there's no evidence that the defendants ever saw this will before their parents died.
Well, that is a separate issue as far as its admissibility, that they've been referred to and described. The objection is overruled. They'll be received.
Oh, yeah.
Right. 142 is withdrawn.
Right.
And for the balance of page 6, there doesn't appear to be any objections. 158 is withdrawn.
Correct.
Are we going?
Well, actually, 158 was just something that I used in ruling upon some offers of proof.
Are we going beyond 4 o'clock, Ron?
Well, let's do one more page here and then we'll
That's what you
let
said.
everybody.
Page 3. You're like the school teacher that says,
Page
put your
7.
hand down, wait till we're finished with this reading.
All right, on page 7, there are objections, 172 and 172 first.
As I recall, and I haven't looked at the slips again, I believe that the visitor slips have conflicting information on them with regard to times and dates.
One of them is a different year than I think it was 89 and it couldn't have been.
That was discussed during the witness's testimony and it was pointed out at that time.
Yeah, so it would be our position, she's testified that she visited 3 times, that there would be no need for these slips, and because they are inaccurate, that could lead to confusion.
Well, but it's been documented as to when it was.
We're objecting to something.
It doesn't seem that it.
The jurors have the physical exhibit in the jury room with them. There's a tremendous amount of information to remember, and whether they would remember that particular bit of testimony as opposed to relying on a document that is timestamped. And the times of the visits become important because of, I presume the prosecution is going to argue that she met with the defendants and then created new testimony. And so the timing becomes critical in terms of when she revealed information and when she visited and et cetera. So, and the fact is that there's only one trip. And when you look at the physical documents, you would assume that there were at least 2 trips to California. So I think it's extremely misleading. It doesn't add anything to her testimony, which is that she saw them 3 times during 1 week. I think it's just going to lead inevitably to confusion.
I don't see it that way, and there's no real potential for confusion because as far as her testimony is concerned, you'll be able to identify it during your argument and refer to the discrepancy in the slips. And if there's any reference to her testimony, I'm sure the jurors will look at their notes and or have the testimony read back, which will contain reference to this discussion we're having right now. So I don't see any potential for confusion. The objection is overruled. 172 will be received. 173 is withdrawn.
The objection to 174 is not that the schedule, nothing wrong with the schedule. It's just that there's correspondence in there. There's a letter. It's put within a letter to, I think, Ms. Lansing, and we would object to the letter portion of it. And
We can modify it.
We'll
Yeah.
withdraw the letter. It's just the schedule we were in.
Okay,
Well,
then if you can,
We'll just modify the document. I know it.
why don't
the ending
you,
too.
why don't you review it then, and we'll put a note here, redact 174. And with the redaction, it'll be received. And once the clerk starts putting stamps on exhibits, I'll ask that council start to review those things during the trial while it's still going on so that you can verify that she's doing things in conformity with our discussions and that when these exhibits go to the jury, they'll be properly marked. And only those things that are received will go to the jury. It's certainly important for counsel to cooperate with the court in that regard. 181 and 182 are withdrawn.
And so we were seeking to withdraw.
183 and 184.
And the people
Okay.
want them.
Well, these were documents prepared by Mrs. Kano relating to her meeting with the defendants and then her meeting with the representatives of the company.
Well, we don't know that she used them with the representatives of the company, but she said these were some estimates, some numbers that she came up with that later proved to not be accurate. And that's why we're objecting to it. I mean, I haven't looked at 184 in a while. 183 is more problematic because she's just throwing around numbers that have no basis in fact, that she said were raw estimates to discuss with the defendants, and she never did get to discuss it with them because they objected that they weren't going to inherit and none of it meant anything to them anyway. So that was the basis for wanting to withdraw.
And the people's theory of relevancy is this. She indicated these two documents help to date when she had the meetings with the defendants. And it's the people's position that she didn't have a meeting with the defendants until the evening of the 24th after the Rolex watches had already been purchased, a position from which she retreated later on. She indicated that she prepared the agenda for the meeting with Eric and Lyle Menendez, which is 184, at a time when she had already prepared 183. And she indicated that she prepared 183, I believe, on that Thursday, which means that the information in 183 was used to prepare 184. If she didn't prepare 183 till Thursday, then she couldn't have had the meeting. That is the argument as to why these are relevant. It's not that the content so much as that the preparation of them dates when she had this meeting with the defendants,
I'm sorry.
Okay.
But the documents aren't dated. So the testimony that she did one before the other and she did the one on a Thursday is still there. These documents don't show that she did one on a Thursday. Their contents don't reveal at all when they were prepared. So all counsel's really relying on is the testimony. Looking at the documents won't tell the jury that at all.
But I think that it's very clear that the information contained in 184 makes a reference to 183 or vice versa. And so what the contents of the documents help dispute her assertion that she had the meeting with the defendants on Wednesday. I could point the court to the specific testimony.
All right, why don't you do that?
She also testified that she wasn't sure.
My recollection is that she did describe some of the detail of these statements. It could have been 182, which is being withdrawn, but
Right.
or 181. She
Right.
did describe the contents of it.
Right, but I recall in my cross-examination of her, looking at them and thinking to myself, these documents prove that she couldn't have had the meeting till Thursday night. So I'm gonna have to go back and look at my
Okay,
cross-examination.
you do that, and we'll hold off on 183 and 184.
What's the IBE?
Reserve ruling on those two.
It's withdrawn.
All right, and 185 is withdrawn. What is the objection to 186?
Well, Your Honor, that 186 is the photograph of Jose Menendez, which the court may recall is very stern. It certainly portrays him as not smiling. It is obviously a photograph that's a professional photograph, and it's not relevant to any issue in the case.
All right, the objection is overruled. It will be received. And any other objections on this page 7 that other than the preserving of the record?
Your Honor, as to 197, I don't recall if those reports are the entire report. Is it his entire package?
Yes, 197 is the entire package. 198 is the records that were used with Sandy Sharp. I suppose we don't need both, and we can withdraw 198 as long as the whole record comes in.
Yeah, well, that would be our objection, is that the entire, we're not objecting on grounds of lack of foundation, but rather that the entire records are irrelevant.
Unless somebody else.
Well, what is it that you're not objecting to then? 198 and 199?
Yes, Your Honor, we will withdraw. Those can be received.
Okay, you have no objection to 198 and 199, but you object to 197 as...
Right, 198 and 199 were testified to by Sandy Sharp too, so that they're relevant for testimony.
The problem is,
Your Honor, that Barbara Howard was also one of Eric's teachers. She identified notes that she had made from the big packet. Now, I can go through and segregate out Barbara Howard comments and prepare an exhibit like 198 for her comments about Eric.
Well, if it was specifically described in her testimony, and some of these were actually read verbatim,
right.
If you could do that rather than as you're doing it here, then you can substitute for 197.
Okay.
If it's redacted, that's fine. So we withdraw objection to 195, 198, 199, and a redacted version of 197.
Okay.
Because all the experts are.
Well,
that doesn't really make it admissible.
Yeah, there was one other teacher who testified. His name escapes me at the moment, but I'll do that for all witnesses.
All right. If you want to then confer with the prosecution in relationship to that, then 197 at this point will not be received until it's redacted in a form that is agreeable to both sides. And everything else I ruled on in relation to page 7, except for those things that have been withdrawn, they'll remain withdrawn. All right, then we'll do the balance of the exhibits. We're at 200 now, so we're about halfway through or so.
we can actually go.
We'll do the balance during the course of next week when we have some time to deal with the rest. All right, anything else now before recess for the rest of the week? All right, we'll be in recess until Monday. Everybody have a happy Thanksgiving.